I am now going to turn it over. Emily is from our Pompano Beach location and has been doing community association law since she was 5 years old. Because look at her, I
Right.
mean, she's been with the firm for quite a bit, but looks like she just started. Emily Gannon, take it away, my friend. Good to see you.
Thanks, Jeff. Hi, guys. So, by the way, special edition today. My
What's that?
mom is watching.
Ah,
So this is going to be fun. It's going to be fun for me. And if we were in a crowded convention center, I'd make her stand up and embarrass her a little bit. But it's just me that knows she's watching, and probably my dad, who is also embarrassed for her. So this will be fun. Now, I'll tell you guys everything I told her too, which is it is a 3 hour course. We have to sort of power through together. I don't want to hear myself talk for 3 hours, but here we are. So I can do it faster usually. We can get it done usually probably in 2.5 hours. Oh, that's my mom. So we're going to do our best. We'll hold questions. If you don't mind, hold all your questions till the end. That's probably the best way to handle it. Typically, this is sort of broken up into sections. If we haven't gotten into a topic, it's probably coming. So wait till we're done and then ask your question. Otherwise, if it's something that I said that maybe you didn't understand, great, type it in real time and we'll look at it in the end. So, like Jeff said, this is a Cape Ender Rembom special. I'm from the Pompano office. I've been here 13 and a half years, practicing for 20 years, actually, kind of crazy. And all we do is association law. That's it. So condos, HOAs, co-ops, and we represent the associations. If you're on a board, then I hope you enjoy what you hear today. And if you need us, we're here to help you if you want. Let's get into the slides. As he said, you will all get a copy of them. So I'm going to try and not just read them because that'd be a little bit boring. I'll try and keep it interesting for you guys. I may skip through some, but you'll have them. So, all right, let's see. Let me go to open up the slides here. All right. Jeff, we're good?
yep.
Okay. All right. There's a little intro page. Like I said, this is the AOA, this is the HOA board certification course. So again, if you're condo or co-op, great. Happy to have you here, but it's not going to get you certified. But you can stay and listen. They're very different now, HOA world and condo world. So we are only talking about HOA today. All right. There's my little intro page if you want to read about me. All right. Let's jump in. So why are we even here? Why do you guys have to do this? Don't blame me. I didn't make it so. Within 90 days after being elected or appointed to the board, new directors have to complete a course now. It's approved by the DBPR. This is one of those courses. The certificate of completion you get today is going to be valid for up to 4 years. You have to do certain additional education as well. You're going to have to do it every 4 years. And this is training that they specifically outlined, things that you guys need to know about as board members: financial literacy, record keeping, fines, and notice and meeting requirements. So you'll see if you go to our website, we do offer a lot of educational courses. We have a lot of seminars. You can watch them online, or you can, sign up for other ones and attend live. We have a lot of them on all of those topics so that you can stay up to date. If you don't file your educational certificate in time within that 90 days, you are technically suspended from the board. Not sure if everyone knows that, but that is the penalty. Now, temporarily, the board could fill that vacancy if they really wanted to. Most boards don't. Most boards don't really know that that's really the way this works. It doesn't impact any decisions you've made as a board if your board members were technically suspended during the time they were making those decisions. Statute is very clear about that, so at least you have that to help you out there. But make sure you're doing your certificate, your certification. Make sure all of your other board members have their certificates too. If they're not here today, make sure you check with them. Mom, I am kind of saying that directly to you. Now, you have to hold on to their certificate for 5 years. That needs to stay in your official records. You should have a copy as well. And like I said, ultimately, if you don't have it, it doesn't affect any of the board actions. So you have that reprieve. All right, continuing education. This was a new requirement. This was put in the statute last year. Essentially now, they want boards to not just have their board members be certified, but to get continuing education. So you can't just take the course once and then stay on the board for a million years and have no idea of when the law is changing and when things are, in flux. They want you to stay up to date. So now, if you are part of an association that has fewer than 2,500 parcels, you have to do 4 hours of continuing education every year. If you're in one of those huge associations, 2,500 parcels or more, it's 8 hours of continuing education. And I apologize in advance because we hear it all the time. We didn't make this requirement but Tallahassee did. They want you guys to be educated. And I know it's just another burden on being a board member, another, issue you guys have to deal with, another headache for you. But here we are.
And
Now,
Emily, can I
yes,
interject? Because the question already came up. I knew it would, and
sure.
it's going to come up several more times about this class certification versus CEU. Can you clarify what this class is for?
Right. So this is just your certification, guys. Like I said, we have other CEUs, the 4 hours of continuing education. We do offer some of those. You have to go to our website. You have to see if you can, sign up for whatever we have coming up. But your 4 hour of additional education is separate. And then you have a certification, and that's today's course. Okay. So your initial sort of your board member 101, so to speak, is what we're doing today. That's the certification for HOA board members. You need that in addition to continuing education. All right. All right. So let's jump into the actual statutes and the meat and potatoes of what we're doing here today. All right. So like we said, HOA, you guys are governed by Chapter 720 of Florida statutes. Co-ops, condos, different statutes. Condos are Chapter 718. That's where you hear the Condominium Act. That's the one you usually hear about more than anything else. Co-ops are Chapter 719, totally different animal. HOAs are Chapter 720. And like I said, HOAs are now very different than condos in many, many, many ways. Those two statutes used to be very similar and in a lot of ways. Now, as time goes on, they're getting more and more, different and further apart. Chapter 718 with condos, highly regulated, a lot more detail, a lot more that goes into it in terms of the statute, administrative code, things you have to follow if you're in a condo. HOA world, it's a little bit more, we'll say loose. Some of my friends like to say HOA land is sort of the wild, wild west in terms of you follow your governing documents. The statute kicks in sometimes, but a lot of times you're following your governing documents and the statutes don't even address a particular item. And your governing documents could say anything, essentially, whatever your developer decided to put in there or whatever your community voted to add into there. Don't know. So that's the running joke of, HOAs are the wild, wild west. So like I said, HOAs versus condos, very, very detailed, oriented, regulated by statute. Chapter 718. That's how condos were created based on the statute. HOAs, different animal based on their governing documents, recorded, again, your declaration, your articles, your bylaws, all of that. That's probably going to control, but the statute does kick in every now and again. Question always becomes, okay, so which version of Chapter 720 applies? This is a whole legal argument, a whole legal discussion we could have. I could talk about this for an hour, this alone. Ultimately, you're going to want to talk to your counsel if there's a question on any of these things, but sort of the Cliff Notes version, so to speak. If your declaration was recorded in the year 2000, the question becomes, so does Chapter 720 from the year 2000 control because we were created under Chapter 720, the 2000 version, or does the current version 2025 Chapter 720 control because now we're in 2025, we're going into 2026, but that's the question. So which version of the statute is going to control? And the way we look at this, there are a couple different things to analyze. Number one, does your governing documents, do they contain the language we call Kaufman language? Is there language in there that says your governing documents, your declaration is subject to Chapter 720 as amended from time to time? Those are the key words, as amended from time to time. If your declaration is amended from time to time, that means you're subject to Chapter 720 as it is amended. So you're following the statute, you follow the changes in the law. So if your declaration was recorded in the year 2000, your declaration is going to travel with the statute. So you'd be subject to the 2025 version right now. If your declaration does not have that language, then you might be stuck back in the version that was in place in the year 2000. Now, for the most part, that might not be significant changes, but it depends on what part of the statute we're talking about. It depends on what item we're talking about. Another part of this is there a substantive right at issue here, or is there a procedural issue here? And the easiest example, and this is a condominium example, but it is the most straightforward one, the condominium statute was changed to outline how they do their elections. It involves 2 notices, a 60-day notice, a 14-day notice, ballots, all of that. And it's outlined in the statute very clearly, the procedure for how they do their election. That was put in the statute, and it was a procedural change. And because it's a procedural change, that applies to all condominiums, regardless of when their declarations were recorded, or regardless of, what year version of Chapter 718 we're talking about, because that was a procedural change. So similarly here, if there is a procedural change to Chapter 720, it's going to apply to you regardless of whether or not you have Kaufman language. Now, deciding if something is a procedural change versus if it's a substantive change, and if you had a substantive right, because your declaration is a contract and it is a contractual right that can't be, impaired by the statute changing. There's case law to that effect, and it has to do with Florida constitutional law, actually, but the statute can't override a substantive right that you had in your contract, in your declaration. So this is where this analysis comes in. And like I said, it gets very complicated, and figuring out what's a substantive change versus what's a procedural change is confusing. And deciding if you have Kaufman language and figuring out which version of Chapter 720 you're subject to gets confusing. So all of these things come into play, and that's probably why you need your attorney to help you out with some of these questions. But those are the things that come up all the time. And we're going to get into why that's important and some of the changes to the statute in recent years that may or may not affect your community. Again, depending on whether or not you have Kaufman language, for example. So interesting. So we'll get into that. It'll all come full circle probably in about 2 hours. Okay. Like we said, procedural versus substantive, that's a big part of this conversation in terms of which version of 720 applies. Is there a legal right, or is it a procedural issue? All right. Chapter 617, that's the one that it governs not-for-profit corporations. That's important for you guys as well. But they made it nice and clear. They changed the statute to specify that ultimately sort of the more specific statute that would address your type of association. So in your case, it's Chapter 720. That's going to control if there's any conflict between 617 and 720. Also, the same story with condos. 718 would control over 617. And they made that nice and clear. Basically, again, this chapter that is supposed to apply to you would control over 617. 617 sort of comes in as almost a backup when there's a gap or when something's missing in 720. We can look to 617 and maybe find an answer there. Another question we get from our boards all the time. Okay, so we have governing documents. We have a declaration. Your declaration is sort of the top of the hierarchy here. So declaration of covenants and restrictions, probably a name along those lines. Maybe it's declaration of covenants and easements. Maybe it's declaration of covenants, easements, and restrictions. Whatever it may be, some version of those words generally is what we see. But your declaration is we like to call it the Constitution. That's your sort of controlling document for the most part. That's the one that's going to have your restrictions in it. That's what's going to outline if you're a 55 and over community, if you have ARC approval, if you have sale and lease approval rights. All of those things should be in your declaration. Then the next document in order of this hierarchy is the Articles of Incorporation. Next one is your bylaws. Your Articles of Incorporation are what set you up with the state of Florida. So that's what you filed with SunBiz. That's what made you an active entity. That is, again, typically there's not much in your articles other than maybe how many board members you have, maybe when your annual meeting will be held, that sort of thing, setting you up again, sort of with the state. Then the bylaws. So we like to joke for the old school ad, a little dab will do you. That's how you can remember. Declaration, articles, bylaws. Your bylaws, again, those typically sort of have your how you function as a board too. Maybe notice requirements, how many board members, maybe that explains your election procedure, your annual meeting procedure, things like that. That should be in your bylaws typically. Sometimes the articles will say something, the bylaws will say something. Again, the articles would control in that case if there was a conflict, but that's where you're looking. So declaration, articles, bylaws, and you can remember that because a little dab will do you. Now, your bylaws, keep in mind, because we do hear, I know it's a term of art, people will say bylaws when they mean the entire body of governing documents. There are different specific governing documents, and you should be referencing the correct one if you're talking about a specific governing document. A lot of people, again, just have a habit of saying, well, our bylaws say this. Well, you may be accurate, or you might actually be talking about your declaration. So make sure you actually know which governing documents you're talking about here. All right, so let's get into sort of how you guys operate, how you're functioning. Membership meetings. Now, we all know your membership meetings probably happen very rarely, if ever. Annual members meeting. You have to hold a meeting of your members annually at the time, place, date that's laid out in your bylaws. So again, your bylaws should spell out when you're having your annual meeting. It could be, they could say it in almost, any way. It might say your annual meeting is to be held January 15th of every month. Or it may say something like the second Tuesday of January, every year. Or it could say nothing other than once a year, or in the month of January, or in the first quarter, something like that. But look at your bylaws, and that's really what you should be following. Your election of directors is supposed to be happening at your annual meeting as well. Again, you look to your governing documents, see when that's supposed to be. If you want a special membership meeting, that could be maybe you're considering adopting an amendment, maybe you're doing some other vote, whatever it might be. It's rare, but if you're thinking about an amendment, odds are you're doing that at a special membership meeting. Look at your documents again, see if there's any requirement there. Typically, if the board wants to hold a special membership meeting, they can do that. But there's also an option for your owners to petition the board and ask for a special membership meeting. That's when at least 10% of your total voting interests petition, or again, a different percentage if there's actually a reference to it in your governing documents. So look there. But you can actually have your members basically force the board's hand to schedule a meeting. Agendas, look at your governing documents, typically may or may not say anything, but your notice of your annual meeting doesn't have to have a description or doesn't have to have the agenda, just has to include a description. But we would tell you put an agenda on there anyway. Why not? Doesn't hurt. A special membership meeting does have to have the agenda on there. And then the business that's going to be conducted is limited to whatever was on there. Oh, what did I do here? Okay. Notice requirements. And I know a lot of times, guys, your managers are probably preparing these things for you, but it's important if you're either self-managed or even if you do have a management team, it's important to sort of double check and make sure you know what they're doing and make sure they're doing it right. So this is important for you guys to know too. Any notices of these meetings have to have the date, time, location of the meeting. If your bylaws don't say anything about sort of a time frame, deadline, whatever it may be, the association has to mail, deliver, electronically transmit a notice not less than 14 days before the meeting. That's usually the magic number. You may have something else in your documents, so you want to look and make sure you're complying with what your documents say. If there could be some strange requirement that your annual meeting requires a 30-day notice, but that's not in the statute. That would have to be in your governing documents. Otherwise, statute sort of defaults back to 14 days. But look in your governing documents, make sure you're following what they say. Evidence of compliance with that notice, with the 14 days, has to be made by an affidavit executed by the person providing the notice. So again, if it's your secretary that's doing the mailing and putting everything together and all of that, they have to sign an affidavit confirming that they, completed that mailing on whatever day and 14 days in advance of whenever the meeting is, or again, whatever your time frame is in your bylaws. Notice has to be mailed or delivered to the owner's mailing address as it's reflected in the official records of the association. So that might be the property address, that might be a different address. And you will have owners who will say to you, well, I don't really live here full time. You know that I also have a home in wherever, New York, Boston, Canada. Why didn't you mail me something there? Well, you are only required as the association to send these official notices to the address that is actually reflected in the official records of the association. So your owners, if they want to have a different official address, they have to let the association know and make sure it's changed accordingly. They can't just say, well, I don't live here full time and I didn't get a copy. Okay. Electronic notice requirements. Obviously, since COVID, electronic notices have really become much more popular. It had really been added to the statute shortly before then, but now it's really something our owners actually use. So the association can actually send notices via electronic transmission, so email essentially, only if the members have consented to receive those notices and they provided the email address for that purpose. Excuse me. So you can't just send everything to your owner's email addresses just because you have an email address. They have to have actually consented to get official notices in that manner, as opposed to, hard copy mailings. The email addresses that they provide to the association where they've actually consented to receiving official association notices, those email addresses become part of the official records. So the other problem is they will be open to inspection, and your owners might not want their email addresses open for inspection. So that's part of it too. If you have them consenting to receive official notices, they have to be aware that that's sort of the trade-off here. And if somebody then withdraws their consent to receive official notices, you have to go ahead and remove that email address from the association records. And there's one little sort of caveat here. If you are doing a meeting to recall a director, you can't use electronic transmission. You can't use email notices. Don't know why, but that's one of those weird things they've included in the statute. Broadcast notice, that's another thing that it's not as popular now, but used to be something more common in a lot of condos more often. But essentially, in addition to sending notices, the board can adopt some rules about posting on closed circuit cable and posting their notices there. What's more important for you guys, because this is pretty new, website posting. So by January 1st of 2025, if you have 100 or more parcels, so we're going into 26 at this point. If you're 100 or more parcels, hopefully you're supposed to have a website now. You have to have a website. You have to post the notice in the agenda of each of the members' meetings at least 14 days before the meeting. The notice has to be plain view on the home page, nice and obvious, or you can have a separate subpage, but it has to be nice and obvious. So it has to be labeled. It has to say notices. We want it nice and easy to find and as dummy proof as possible. Has to be very conspicuous. And if it's on the app, it has to, same thing, be labeled notice and be, linked from the home page. But they want it really on the home page so you can, there's no question, you posted the notice and it's basically the first thing you see. Nice and open and obvious. You also have to post on the website any document that is going to be considered or voted on. And they do give you a little time for that. It's at least 7 days before the meeting at which the document's going to be considered. That's also part of the requirement now. Members have a right to participate in these meetings. Obviously, if it's a membership meeting, that's a little more obvious, but you have to give them the right to attend and they have the right to speak too. And this is in reference to any item that's open for discussion or any item on the agenda. That's why we'll tell you typically, for your agenda items, don't keep them open-ended. Don't make them very, broad and vague. Kind of keep your agenda pretty detailed so that you actually know what you're kind of opening up for discussion to your owners. Now, your owners have the right to speak for at least 3 minutes. You can adopt some reasonable rules about frequency, things like that. You can require that, everyone sign up before they speak and we go in that order or whatever it may be. You also have to make sure that the location is accessible to any physically handicapped persons for these meetings. A handicapped person who has a right to attend the meeting, obviously. An owner is allowed to tape record or video record the meeting. I know this is now something that's become more common because people can just do it on their phones. It's very easy. But the board can adopt rules about that too. You might not want a whole, camera crew coming in with an owner with a boom mic and, a huge video camera or whatever it is. That's fine. You can adopt rules. You still can let them record the meeting, but without all of the, fanfare. Or that they can't, come up to the table with their cell phone or with a microphone and shove it in the board's face. You could adopt rules, make it reasonable. They have to let you know that they're going to be recording. They have to, if they have equipment, they have to set it up in a certain way, whatever it may be. So again, it doesn't interfere with sort of the operations and the actual meeting. All right. Quorum and decisions. So quorum is a funny word. We all know it's a weird sounding word. And it sounds big and scary and important, but it's essentially all it means is it's the least or the smallest number of people required to have your meeting. It's the threshold you have to hit in order so you can actually conduct your meeting. Typically, I say people, but really it's, voting interest or however your governing documents establish it. But your governing documents, this is one where the statute actually came in handy and helped HOAs. Unless there's a lower number in your bylaws, 30% of the total voting interests is your quorum requirement. So if you have bylaws that have old language and it says something like a majority or, 2/3 or 60% or some other high number that you would never, ever hit probably, that's okay because the statute kicks in and it's unless there's a lower number, we're using 30%. A lot of the governing documents will say something like, a third or again, a majority, but it's 30% unless there's something lower. So if your governing documents actually were written fairly recently and they only have 20%, great, you get to use the 20% as your number. And as long as we hit that, as long as you have that 20% in that case or 30% in almost everyone else's case, present in person or by proxy, we can conduct the meeting, we can go forward and we can do the business that we came to do. All right. To make decisions, for the most part, when we're talking about membership meeting and making decisions, usually it's a majority of the voting interest present as long as quorum has been obtained. But again, you have to look at your governing documents because there might be a different threshold depending on what you're voting on. Proxies are very important because to hit quorum, again, to actually achieve quorum, to be able to function, to move forward with your meetings, to be able to, conduct business, first step is hitting quorum. How do we get that? You need people present in person or by proxy. So you need probably some proxies. You need people to actually participate, get some owners to turn in their proxies if they can't be there in person. All well and good. Generally, owners have the right to vote by proxy. Again, look at your governing documents, see if there's anything unusual there. But to be valid, a proxy has to be dated. It has to include the date, time, place of the meeting. So it is supposed to be given for a specific meeting. And it has to be signed by the authorized person who can execute the proxy. So make sure if you're one of those communities where you need voting certificates or and you enforce them, that the same person who is the assigned voter, the voting rep or the voting member of that lot, is the one who executes the proxy. A proxy is effective only for that specific meeting for which it was given. And if that meeting gets continued and adjourned and all of that, that's still good. The proxy still counts. You're okay. But you have a 90-day window before that proxy is going to expire. And it's 90 days from the date of that meeting that it was, for which it was given. So date of the meeting, if your meeting is, set for December 20th, that's all well and good. Your proxy is going to expire 90 days after December 20th. So if you're trying to get a vote, you're trying to get maybe an amendment to pass, all well and good. You may have to sort of continue the meeting. You may have to push it back. You may have something going on. You're so close, but you just had some members that are out of town because it's a holiday or whatever it is. We want to try and come back in 30 days. Those proxies are still going to count. Those proxies are still going to be good because you're still within that window. But after 90 days, you can continue the meeting, continue the meeting, continue the meeting. But if you hit 90 days, then those proxies are going to expire. So be aware. Proxies are revocable at any time by the person who executes it. So you can have an owner who signs a proxy and then they end up coming to the meeting and they say, oh, you can give me back my proxy because I'm here. Great. That's fine. Not a problem. They can also change their mind if they voted in a proxy, on a proxy, and we'll get into the difference with the limited and a general. They can change their mind at that point too and say, give me back my proxy. I'm going to change my mind. I want to vote. Now that I've heard the arguments, or now that I, talked to my neighbor, I'd like to change my mind. And that's fine if we're talking proxies. Copy of a proxy can be used if it's a complete reproduction of the original proxy. We do tell everyone if you have the original, or ask the person to then send you the original so you have it too, but copies are okay. General proxies versus limited proxies. There's confusion about this too. A general proxy generally, gives the power to another person to make decisions for you. So they can vote in any way that it would come up at a meeting, and it would count towards quorum. So you could give a general proxy to your neighbor, to your friend, to whoever, and go, here, I can't make it to the meeting. Here, you can basically be me at that meeting, and you can vote on my behalf. And I trust you to make those decisions for me. All well and good. A limited proxy is different in that it actually lists the item being voted on. So for certain things, you need to vote by limited proxy, probably a proposed amendment, something like that, where you actually want to give your proxy. Maybe you are out of town. You want to give your proxy to a neighbor to say, hey, I want to vote in favor of that amendment, but I can't be there. Can you hand this in for me? And you would have signed it as the owner, and you would have checked the box that says, yes, you're voting in favor of that amendment, or no, you're voting against that amendment. So that person who turns in the proxy already knows what your vote is, and they're just basically delivering it for you. They're not really exercising the vote. They're just, again, kind of delivering it for you. And both types of proxies in that case count towards quorum, which is, again, very important, because that's the first step. That's the first hurdle. That's the first threshold we have to hit before any votes can happen, before we can take any action at a membership meeting. Electronic voting. All right. So again, something that really became popular after COVID. Electronic voting, I know, used to kind of scare people because the internet and apps and, all of the technology, and not sure if it works for our community. And people were scared of the price. Now, from what I understand, when you really kind of weigh out how much it costs to do the electronic voting versus mailing everything, it's not so bad. And my understanding is it's pretty easy. The way they have these platforms set up now, it's pretty foolproof, and people can figure it out pretty easily. And it does make things a little bit easier when we're trying to get these votes to pass, and you're trying to get your owners involved, and maybe you're trying to get some amendments going. And it is very hard to have your owners actually show up for meetings. Again, maybe it's a snowbird type community. Maybe your owners just aren't that interested. They're not around. They travel a lot, whatever it is. Electronic voting helps you get that participation, helps, people vote from all over. But the electronic voting is essentially, like I said, it's through a platform. So you have to hire a third party. There are a bunch of companies now that will do it. And again, from what I'm hearing, the prices are not so bad. So it's not as scary as it used to be. But to set up electronic voting, there are multiple steps, and there are some things you need to be aware of. You need to make sure it complies with everything that's required. The first step is the board has to adopt a resolution explaining that they're going to allow the community to now have electronic voting. It's a 14-day notice for that board meeting. That's unusual. Normally board meetings are 48 hours, 14-day notice. That notice has to go out, mail, delivery, electronic transmission, and has to be posted in the community. You have to have an affidavit of mailing, same thing as any other sort of special meeting of your board. The board resolution has to spell out that members are going to get a chance to engage in the online voting system, has to outline the procedures and how this is going to work. Again, if you're thinking about doing electronic voting, talk to your counsel and get the guidance, and they can probably prepare the resolution for you. And again, you probably want to have already sort of vetted out which platform you're going to use. Talk to those vendors first before you proceed. That's probably easiest. I guess we should have also said, because I don't know if we said this right in the beginning, everything we're telling you here today, guys, it's all for education. I'm not really giving you any legal advice. If you need legal advice, talk to your counsel, or, you can always hire us later if you really want, but this is all educational. Okay. So an association can conduct their membership meetings and their membership voting and all of that through this online platform. You don't have to require that everybody does it. You just have to give the owners the opportunity to consent and to agree to do it. If you have owners who are resistant and they don't want to do it this way, they can still vote the old-fashioned way. That's perfectly fine. But this just gives the opportunity to those owners who would rather vote electronically to be able to do so. Now, and they can do it until they opt out if they want. And the other perk is if they vote electronically, they're counted as being in attendance, so it counts towards quorum as well. So if they cast their vote through the online platform, you're going to know Mr. Jones cast his vote, and Mr. Jones basically counts towards our quorum requirement, even though Mr. Jones might be, in Madrid for the holiday. Again, like I said, electronic voting, there's a lot of standards it has to meet. All of the platforms, my understanding is the platforms that are out there all already comply, but these are things you just need to know. The association has to let the owners, again, work with the platform. The platform has to be able to authenticate the owner's identity, because you want to make sure you can confirm that Mr. Jones is Mr. Jones. And he's the one who's logging on at, mrjones@gmail.com, and he's the one casting the vote. So there has to be some sort of checks and balances here. But again, the third-party platform should be able to do that for you. The association has to use an online system that can, again, authenticate the identity, also transmit a receipt to the owner to confirm to them that they voted. But the big thing here is they have to be able to separate out that we know Mr. Jones cast his vote, but we don't actually know how Mr. Jones voted, because your votes are supposed to be anonymous. So if you had an election, for example, you wouldn't know that Mr. Jones voted for candidate, A, B, and C, and didn't vote for D and E. Here, same thing. The system would know that candidates A, B, and C each got a vote, and they would know that Mr. Jones voted, but there would be no way for you to know that Mr. Jones voted for candidates A, B, and C. Very interesting the way they do this. And they have to be able to store those votes. They have to be able to, track all of that so that the association would have those records if they needed them. All right, this brings us to elections. All right, let's jump into elections. So, election of directors, and we're in election season now. Hopefully, I don't know if you guys have had your elections yet. Usually they're first of the year, early parts of the year, but we've had November and December elections as well. A vacancy on the board that's caused by the expiration of a director's term is filled by an election. Now, that's different than if there's a vacancy because a director, left or retired or whatever it is. That's different. We'll talk about that later. But the election is supposed to be done at your annual meeting. Again, look at your governing documents, see what the governing documents say about when you should be doing that. It has to be following the procedures set up in your governing documents. Again, very different than condos. HOAs, you follow your governing documents when we talk about elections. A quorum has to be established first, because like we said, the quorum is the number you need, is the minimum number you need to conduct business. So you need to hit that quorum threshold in order to have your election, because the election is an item of business happening at your annual meeting. If we don't hit quorum, we don't have a meeting, we don't have an election. This is, again, why HOA and condo are very, very different. That's a very different story in condo world. The election is completely separated out from the quorum requirement. HOA world, you have to have quorum. This is why we hear all the time, hey, our association hasn't had an election in 10 years. We never have an election. The board's always been the same. We can't get a new board. Nobody can run. This is usually why. We hear those complaints all the time. And I know why. It's because you can't get quorum at your annual meeting. That's the first step. So if you come up and ask us, hey, we want to have an annual meeting, we want to actually have an election, we need to, get some fresh blood maybe on the board, or whatever your reasoning is, I'm going to tell you, step one, you got to get quorum. So you have to go out, get some proxies, get your owners to show up, whatever it is, gather the proxies, knock on doors, tell your owners to show up. If you can't do it, if your quorum requirement, if you can't hit it, then you're not going to have an election. So again, that's sort of number one biggest difference between HOA world and condo world. You guys need quorum in order to have your annual meeting, in order to have your election. So that's usually, again, my biggest tip to you, if you want to make any changes, you're going to need to get quorum. You probably need to go around, knock on doors, get some proxies. All right. Okay. Candidate eligibility. This is another question we get all the time. Hey, who's allowed to run for the board? Does the statute say anything about, who can run, who can't run? And we get some fun stories. Don't get me wrong. We will hear, hey, so-and-so, Mr. Johnson's actually suing the board. Or suing the association. So he can't be on the board, right? Nope, that's not necessarily true. Or, Mrs. Smith has a million violations. She painted her house the wrong color. She won't change it back. We're going to end up having to sue her. She has grass that's too high, hedges that she didn't get approval for, all of these things. So Mrs. Smith can't run for the board, right? Nope, that doesn't preclude her from running either. These are all, again, fun scenarios. We hear them all the time. The only time you can't run is if you're not eligible, and those are the things that are laid out in the statute. Now, I should give you a little context for this as well. Used to be pretty simple in terms of what the eligibility for your candidates was. They've changed it in the last couple of years, and a lot of the stuff we're about to get into were changes probably from the last couple of years. A recent theme, we'll say, that we saw in Tallahassee was to address certain news stories you guys probably heard about or saw on the news. Last couple of years, there were some headlines about some associations and some boards that were doing things they shouldn't have been doing. Allegedly. Let me just say that. But there were news stories of boards embezzling money, some, fraud and setting up companies that were not real companies and paying, a fake landscaper to just basically embezzle the association's money or do whatever they were doing, or paying their, brother for nothing and taking the association's money. There were a lot of those stories in the last couple of years. And I shouldn't say a lot, but there were a handful of them in the last couple of years. And there were actually a number of arrests and a lot of money that did allegedly get stolen or embezzled from various associations. And this became sort of a hot topic in our area of practice. Because of that, Tallahassee sort of, decided we got to lay down the law. We got to make sure we don't have this problem again. We want to make sure our boards are doing the right things. We want to make sure no money is being embezzled from the associations, that they're not stealing, that they're not doing these inappropriate things with our owners' money. So you'll see a little bit of that in some of these changes. First thing that makes you ineligible to run is if you're delinquent in the payment of a monetary obligation on the last day that you could nominate yourself for the board, then you cannot seek election. You cannot be listed on the ballot. Okay. So if you're an owner who's delinquent in the payment of any monetary obligation on the last day that you can nominate yourself, so that's probably at the actual election, probably, from the floor when they're opening up the floor to nominations, you have to be current. You cannot be delinquent. If you're delinquent and it's payment of any monetary obligation, that could be a fine, that could be, late fees, that could be something you're disputing, whatever. If you're delinquent, you're not going to be eligible. You can't run for the board. They can't put your name on the ballot. Now, I will tell you, I've had people, and it's a little awkward when you show up to do the annual meeting and to do the election, and a board member pulls you aside and says, hey, that guy over there, he told me he wants to run for the board. He told me he's going to, raise his hand this year and nominate himself. But we checked his ledger and he actually owes, $200 because he missed a payment or something. Gets a little awkward. And obviously, and in person, I can tell him, pull him aside and say, hey, when you raise your hand, I'm going to have to say you're not eligible, or maybe we can resolve this delinquency. And in that case, that man pulled out a wad of cash and paid the manager right then and there, and he was no longer delinquent. He got to run for the board. Sometimes it's not quite that easy, but that's what you need to make sure, that all of your candidates are current, nobody's delinquent, then they're okay. You can put them on the ballot. Another one to be aware of, if they've been convicted of a felony in Florida or another jurisdiction, and it's the offense that would be a felony in Florida, and they have not had their rights restored for at least 5 years, that makes them ineligible. Again, you're going to tell me, we have no idea if people are felons. We don't run background checks on our candidates. Well, some associations might they might be aware because you might have a background check because maybe you ran a something when they applied to, for the sale or lease of the home, whatever it was. Maybe you are aware of that. Typically, that's not one we see. That one doesn't come up very often. And I would not tell you to start running background checks on candidates either. That's not recommended, but that's something to be aware of. This last one is the one that is the most recent. Like I said, it kind of goes with our recent theme of board members behaving badly. We'll say it that way. Any person who has a pending criminal charge. So it's pending criminal charge. It's not a conviction. Pending criminal charge for forgery of a ballot or voting certificate, felony theft or embezzlement offense involving the association's funds or property, tampering with physical evidence, destruction of or refusal of, allowing official records inspections because you've either destroyed the records or you're interfering to prevent, again, kind of hiding a crime that you've already committed, to prevent them from discovering the documents, or obstruction of justice. So any of those pending criminal charges, you're not eligible. You're not going to be able to run for the board. Again, all of those are new. Those are, the last couple of years we've added that in. Nominations. So like I said, you have to be eligible the last possible chance you have to nominate yourself for the board. You may say, well, when do we nominate ourselves? Do we, is there something where we can do notices of intent in advance? We can let everyone know who wants to run for the board and do nominations. Now, again, in the world of condominiums, there is an outlined procedure. It requires the 2 notices. It requires all of, very specific procedures to be followed. HOAs don't have that. So if you want that, if you want some sort of notice of intent deadline, if you want to do a first notice and then let everyone know, hey, we want to know if you want to run by this date, and then we'll know who our candidates are, and we could send out a ballot in advance and we could let people vote in advance. You could do that. It would need to be in your governing documents. You probably have to do it by an amendment. You probably have to have your owners vote on it. You could make your procedure like a condominium. We do have a lot of HOAs that prefer that because then, again, you know who your candidates are in advance. It allows people to campaign. If people aren't in town the day of the annual meeting, they don't have to worry about it. They've already let everyone know they're running. But most likely, in most cases for HOAs, you don't have a procedure like that. Your governing documents probably just say the annual meeting is to be held in whatever, January, let's say, and we'll take nominations from the floor. And then you show up and then you open up the meeting. Hopefully you've achieved quorum. You open up the meeting and say, okay, does anyone want to run for the board? Basically, do we have any nominations? And you let people then and there raise their hand, nominate each other. Hey, I think Mary should be nominated. Oh, I think Jim should be nominated, or I'd like to run. Okay, cool. You take nominations from the floor. You open up the floor for nominations. Once we're done, motion to close the floor. And that's it. And we don't know who our candidates are until the night of the election. And then, like I said, oftentimes, if we don't even hit quorum, you don't even get to that step. We don't go forward with the election because we didn't have a meeting, because we don't move forward with the election. So if you want to do your nominations in advance, if you want to, make this more like a condo procedure, talk to your attorneys. Maybe it's an amendment you want to draft. You may have something in there that is kind of a hybrid. You might have language in there that says you can have a nominating committee, and the nominating committee will accept nominations in advance. The caveat there is owners have to be able to nominate themselves. So if you have old language that says a nominating committee will pick their favorite 3 residents, and those will be their candidates that they present for everyone, that's not going to work in terms of then you would still have to, let me say it this way, then you would still have to take nominations from the floor. If it's a procedure where the nominating committee just takes all candidates, all, notices of intent, let everyone know you can nominate yourself. If you want to be a candidate, just tell the nominating committee by this date, then you wouldn't have to take nominations from the floor. As long as you've allowed people to nominate themselves in advance, then you don't have to do the nominations from the floor. But again, it's a little tricky. And if you are not quite sure how your election should be done, and if you want to do candidates in advance or not, talk to your attorney. This is probably something you want to amend, and you can probably clean it up that way and do your amendment, make your election more like a condo. So on election day, if we've again opened up the floor, we've taken our nominations, maybe you have 5 seats and you only have 4 people who want to run. Well, good news there is you don't have to hand out ballots. We don't have to do a tally. We don't have to do any of that. If you have the same number or fewer candidates than seats available, great. You just seat your new board. That's it. We don't have to do all the rigmarole there. If you have more candidates, so if you have 6 people raise their hands for 5 spots, then you're handing out ballots. You're going to let the owners vote and vote for their favorite 5 or whatever it is. Owners have the right to vote in person or by proxy unless there's language in your governing documents. Again, very different than condos. Condos have a completely different election procedure, but you can show up with a whole bunch of proxies. So maybe you're one of those owners that said, this year, I really want to get on the board. I want to make sure we have an election. I want to make sure we get quorum. I've been knocking on doors. I've been talking to my neighbors. I got a whole bunch of proxies. I'm going to show up with, 20 proxies in my hand. And there you go. So maybe you're one of those owners and maybe you actually do hit quorum. If you show up with 20 proxies, guess what? You get to vote for yourself and you get to vote for those 20 people that you just, are representing by proxy. So you really get to vote 21 times. You would get 20 ballots, plus your own, or your ballot would count 21 times, however they wanted to handle it. You may carry the whole vote. You may basically get to pick the whole board if it's enough. So that's interesting. Then, and again, we never really know what's going to happen at an annual meeting. That could happen, or people could show up with no proxies and we have no election and everyone goes home in 5 minutes. Just never know. That's why the joke is it's a little bit of the wild, wild west. Board terms, again, look at your governing documents. Typically, the term is going to be 1 year to be a director, but your governing documents might have something different. Maybe you have staggered terms. Maybe your half of your board gets elected this year and they get to stay on for 2 years. And then next year, the other half gets elected and they get to stay on for 2 years. And you're doing sort of a swap of we elect 3 this year, 2 next year, 3 the following year, 2 the following year, so that you end up kind of with some consistency on the board. That's the thinking. If you have board members who have a 2-year term, it gives them sort of more time to get things done and to kind of stay on the board and, again, have that consistency. Maybe you have some projects in the works, that kind of thing. But that would have to be something, again, in your governing documents. Otherwise, the assumption is the term is 1 year for everybody. Election challenges. If you have an election challenge, that has to be commenced within 60 days after the results are announced. That's probably going to go through the division. It can go through binding arbitration or filed in the court. It would go through the division if it's a binding arbitration. Election of officers, and this gets confused sometimes too. When we're talking about electing your board, your owners get to decide who's going to be on the board. That's who they're voting for. Again, assuming you're a board of 5, your owners are voting for those 5 people. Now, once we have the board of 5, once we've gone through the nominations, we tallied all the votes, we have our five new board members. We've announced, okay, these are our 5 new board members. Thank you, everyone else, for your interest. Here's our new board. Now the question is, who becomes president, who becomes vice president, treasurer, secretary, any other officers you may have. That is not up to your owners. That is up to those 5 people. Those 5 board members get to decide who's going to be what officer position. So it is a little different. It's a little confusing because I've been at meetings and someone will say, well, but we all really like Bob. We want Bob to be the president. Okay, thank you. Thank you for voting. And Bob is on the board. But now who's going to be president or who's going to be any officer position is up to these 5 people. You as an owner who voted already, that's it. Your part's done here. But it really is up to those 5. So they get to decide. And typically it's the organizational meeting and it's held right after the election. You can look at your governing documents. You don't have to do it at the same time. Maybe you do it a little bit, you do it in a couple days if people aren't present or your meeting went really long or whatever else might be going on. Should be within at least 10 days. That's usually the max. But ultimately, organizational meeting is to just organize the officers. They get to decide and nominate each other or themselves. Hey, Bob, do you want to be president? Does anyone else want to be president? No, great. Bob, you're our president, basically. If there is a dispute, if you do have sort of 2 factions, Bob wants to be president, but so does Mary. Everyone else gets to vote, and we decide that way, and it's just the board members who get to decide. And fun trivia fact here: directors don't get to vote by proxy or secret ballot at any board meetings. The only time they can use a secret ballot is to vote on who are going to be those officer positions and to vote at the organizational meeting, which again makes it a little less awkward if you had a heated, contentious election and you end up with a board that's kind of split and people don't maybe necessarily want to let everyone know who they want as president. So they would get to do that by secret ballot. Now, another thing to be aware of, there's no prohibition against changing officers midterm. So that means maybe you decide the night of, okay, Bob's going to be president, Mary's going to be vice president, Joe's the treasurer, Susie's the secretary, and Bill is our fifth director. Well, at some point down the road, maybe you decide Bob's actually kind of a terrible president because he's either not around, he's hard to get in touch with, maybe he had a health issue, he just doesn't have the time anymore. Okay, we want to reorganize. We don't think Bob should be president anymore. You can do that at a regular board meeting, 48-hour notice. Just put it on the agenda. You're going to reorganize, and maybe you make Mary the president now, or maybe, however you want to do it. That would, again, be entirely up to the board. They could do it at any point in time. All right. And it doesn't mean you're taking Bob off the board. It just means he's no longer the president. You're giving him a different officer position. That's a board decision. Fraudulent voting activities. Okay. So, like I said, this was a hot topic the last couple of years. And it makes sense when you do have board members who were doing illegal things and embezzling money and stealing association funds. They then were not, conducting their elections properly because clearly they needed to stay in power, and they were not doing things on the up and up. So we, again, sort of reiterated now that even though these things should have been illegal before, now they're really, really illegal because now we've also put them into Chapter 720. So person who engages in the following acts commits a first-degree misdemeanor. So we're not messing around. Elections for HOAs used to kind of be a joke. Now it's no joke. If you guys do things you're not supposed to do in connection with an HOA election, you actually might be guilty of a first-degree misdemeanor, a crime. It's, again, not a joke anymore. Now, again, I would hope you all knew this and you wouldn't be doing those things anyway, but now we've put it in the law and we've made it nice and clear. It's in Chapter 720, in addition to already being its own crime. Willfully, falsely swearing to or affirming an oath or affirmation in connection or arising to voting activities, that's now first-degree misdemeanor. Perpetrating or attempting to perpetrate a fraud in connection with a vote cast or to be cast or attempted to be cast. Preventing a member from voting or preventing a member from voting as they intended, basically, intimidating someone to change their vote, something like that. Menacing, threatening, using bribery or other corruption to influence someone's vote. All of those things now are considered first-degree misdemeanors. Bribery, love that. It's great stories here. Giving anyone something of value with the attempt to, buy their vote. That's, again, not allowed, but they do specify that doesn't apply to any food served, an election rally, or something of nominal value. So a campaign pin, a sticker, whatever, those little tchotchkes, that's fine. Using or threatening to use force, violence, intimidation, any tactic of coercion to compel a member to vote or to stop them from voting or to vote in the way they want to vote. All of that now is under this umbrella of fraudulent election voting activity. All of this could result in a first-degree misdemeanor charge. Now, each of the following constitutes a first-degree misdemeanor: knowingly aiding, abetting, advising a person in the commission of fraudulent voting activities, agreeing or conspiring with at least one person to commit a fraudulent voting activity, or having knowledge of fraudulent voting activities, or trying to aid that person with the intent that to arrest or to avoid arrest or punishment or some other, other penalty. Now, they did specify that doesn't count for attorneys who are aware of these things that happen. So we do get that one privilege there. Vacancies on a board. So getting elected is because the director's term is ended at the annual meeting and we're having an election and filling it that way. If there's a vacancy on the board, that happens a different way. So if basically an opening comes up because someone has resigned from the board, they've moved out of town, they just can't do it anymore, maybe they got sick, whatever else. If you have a vacancy on the board and it's before the end of the term, and we're not talking about a recall, we're just somebody has left the board for whatever reason, the rest of the board can vote to just fill that spot. So look at your documents, make sure there's no different language in there first. But generally, the affirmative vote of the rest of the board, a majority of the remaining directors, gets to just fill that spot. They can appoint someone else, and they would fill that spot for the rest of the term of that vacancy. And again, another fun trivia fact, that is even if there is only one director left. So if you're one of those communities that has a smaller board, maybe you're only a board of 3, and one person tells you they're resigning because they don't have the time to do it anymore. Another person resigns because they're moving out of the community. Now you're left with a board of just one person. That one person can't really function. They can't operate. They don't have quorum of the board. They can't make decisions on their own. So the first thing they're going to need to do is to appoint someone else to the board. So at least we have 2 directors. Now we can actually function. Now we have 2 directors. We have a quorum of the board. They can make decisions. They can make, they can take action. They can do what they need to do. I would still say now those 2 should appoint a third, and then we really fill the board. But that's the one thing that a solo board member or a board that doesn't have quorum can actually do, is appoint someone so that you get to the quorum number. And it does make sense when you think about it. And then you want to look at your bylaws to make sure the person is filling that vacancy for the remainder of the term, or if there's something else. Again, if you're one of those communities where you have staggered terms, maybe there's really a year and a half left on that, in that director's term that this person is now taken over. Does that new person serve the year and a half, or do they just serve the next 6 months until the next election, and then you just treat it like it was a new vacancy at that point? Could go either way depending on what documents or what your documents say. All right, board of directors. Let's get into some fun stuff there. Okay. Hopefully you guys know, shouldn't be new to anyone here, if you're on the board as an officer, as a director, you have a fiduciary responsibility to your owners. Fiduciary responsibility, I know you see it in some commercials now where there's some accountant guy that says, I'm a fiduciary. That means I care about your needs too, or whatever. Basically, a fiduciary puts the needs of others above their own. That's what you're doing really as a board. You are supposed to be doing what you believe is best for your community, for the association, not your individual, needs. If you're a board member, and when you think about it again, this does make sense. If you're a board member and you made every decision based on what benefits you and only you probably would never want to increase the assessments. You'd probably never agree to the adoption of a special assessment, because who would ever want to pay more money? But when you're on a board, if you know the association needs more money to operate because costs have gone up, or you need a special assessment because you have a project, you have to do a new, roof on the clubhouse, then as a board member, you make that decision. You don't think about the fact that individually that money, now you have to pay that money. That's how a board member should be functioning, right? So you make that decision, you do what you believe is best for the community. Now you have to act reasonably. There's something in the law called the reasonable business judgment rule. There's case law behind it. You are protected as a board member when you make decisions if you are following the reasonable business judgment rule, if you make decisions reasonably, if you basically guide your decisions on, what your experts are telling you, if you confer with your attorneys, confer with your accountants, talk to an engineer when you're doing projects, things like that. If you don't trust your experts and you don't do sort of your due diligence when you make decisions, then you might run into a problem. But you should be following the advice of your experts. You should be acting reasonably. Now, again, all board members aren't going to make decisions the same way. You're not going to agree on absolutely everything. You may have a difference of opinions on how to adopt that special assessment. Well, I think if we adopt it, in one fell swoop with one due date, our owners, it's going to be a problem for our owners, and we're not going to be able to, we may run into collections issues down the road. Someone else on the board might say, well, if we don't do it in one fell swoop and one due date, then we're going to have problems with the project because it's going to delay the project. We need the cash right away. Those are both very reasonable arguments. You could have directors that, again, have a difference of opinions, and they're both reasonable. They're both logical. They're both supported, and not a problem. Again, you're going to be protected from personal liability as a board member as long as you're acting reasonably, like any other board member would. You're relying on the advice of your experts, and that's how you're making your decisions, not based on your own sort of selfish wishes. No one board member should be making decisions for the board. That's important. We hear that all the time too. We have this one president, and he's basically running the whole community and nobody else gets to say in anything. That's not how it should be. Your board should be making these decisions, not one board member, not the president just because he's the president. Now, it does say unless delegated, so you could actually delegate as a board, you could delegate some decisions to an individual board member. Hey, we actually do have the president in charge of, vetting some vendors, and he's going to be the one to bring us what he thinks is the best deal, whatever it is. That's fine if the board decides to do it that way. But again, it's not a dictatorship here. You should not have one board member who's running the show. Directors can't vote by proxy or by secret ballot. Like we said, the only time they can use the secret ballots is the organizational meeting or a vote on organizing the board. Members can vote or can use email, but you cannot vote via email. That's important because we get that all the time, that members of the board use their email and just make decisions by email, and they don't really hold the meetings they're supposed to be holding. Your decisions are really supposed to be made at board meetings. Your owners should have an idea of what's going on, or at least if they don't come to the meetings and they don't, know what's going on, that's at least, on them. That's their problem. If you're making these decisions at board meetings that are properly noticed, your owners, in theory, who come to the meetings and who pay attention, should know what's going on. There should be transparency. There shouldn't be any surprises. You shouldn't be conducting your business in the dark, in the shadows, hiding from your owners. Board meeting notices are supposed to have, again, date, time, place of the meeting. All agenda items should be on there. If you're adopting an assessment, especially if we're talking a special assessment, you need to put on there that there is going to be a special assessment adopted, the purpose of that special assessment, if you, the purpose, and then essentially the estimated cost. So if you're doing a special assessment because we're paying for the roof of the clubhouse, you want to indicate on there, it's a board meeting to adopt a special assessment. Special assessment in the agenda item is going to be vote to adopt or to consider special assessment to replace, repair, the roof of the clubhouse, in the amount of approximately whatever the number is, $200,000. Now, you may not have finalized those bids just yet. You may not know exactly what that roof number is, but at least in that notice, and it's a special notice, it's a 14-day notice, at least in that notice, you've identified what the purpose of the special assessment is and the estimated price or estimated cost. Now, again, if it comes in a little different, you should hopefully have that number by the time you adopt the special. You've locked it down to, it's actually going to be $197,500, whatever. Fine. If your notice said 200,000 and you come in at 197, great. Perfectly fine. Your notice is fine. It should be, not an issue. But you want to make sure, again, 14-day notice, look at your bylaws, make sure you don't have a weird requirement there or any additional time that it needs to go out. It has to be mailed, delivered, transmitted to all of your owners, has to be posted on the property 14 days before. That's a special board meeting, all right? So special assessments are not normal board meeting notices. It's not 48 hours. Most of your meetings are 48-hour notice. Special assessment is 14 days. Also, the other exception, if you are considering an amendment to a rule regarding parcel use, it's a 14-day notice, all right? The association has to adopt a rule or may adopt a rule about conspicuously posting your notice and your agenda on the website. And you can post on the website or you can send out email blasts as well if these are electronic notice. People have consented to electronic notice. The notice has to have a hyperlink to the website if that's what you're doing. And then any rule has to include a requirement that the association send electronic notice as well, again, if they've opted in, and to the email addresses that are in the official records. We covered this, but we'll just reiterate it here. January 1st of 2025, if you're an association of 100 or more parcels, you have to have a website or an app, an application, whatever they call it, but basically a website. So website that has your notices where you can post this information. You also have to have certain documents, and we're going to get into that, what needs to be on your website. But now it's 100 parcels or more. Everybody needs to have a website. Hopefully you already do. Okay. 100 parcels or more, you need a website. Member participation at board meetings. So this is not that different than when we talked about membership meetings a little while ago. All of your board meetings are going to be open to your owners. Your owners get to come, except only two exceptions. Meetings held for the purpose of discussing personnel matters. So if you have, maybe a maintenance man on site and you need to discuss an incident that happened with him or whatever, or writing him up for something, that's a personnel matter. That's something that the board would do at a closed board meeting that wouldn't be open to all of the owners. But personnel matters, that's one. The other one, the one that comes up more often for us, obviously, is meetings between the board and the attorney. The attorney has to be there too, whether it's via Zoom or on teleconference or whatever it is. The attorney has to be there. If you're saying it's a legal meeting, because we hear that all the time, we have to have a closed meeting because it's a legal meeting. If you're meeting with the board and the attorney to discuss proposed or pending litigation, okay, then that's one of the exceptions. So you don't get to use that as a blanket, well, we want to have a closed meeting, so we'll just say it's for legal and we'll just not let people come. No, it has to be with the board and the attorney, and it has to be to discuss proposed or pending litigation, okay? Again, the attorney doesn't need to be there physically. They could be on the phone, but don't use us to try and get out of having open board meetings. We don't like that, okay? Members have the right to attend all the board meetings, except the ones we just talked about, those two, personnel or pending or proposed litigation, and the right to speak at board meetings with reference to all designated items. The association can adopt reasonable rules. So again, you could make them sign up to speak and sign a list when they want to speak. There's no time limit technically in the statute, but again, we use the 3 minutes sort of as the guideline. That's a reasonable rule. Each owner can speak 3 minutes on an item. Recording, handicapped access, you can tape record or video record any of the board meetings. Same thing we talked about before. Again, you could adopt rules. You can make them, they have to be reasonable. You don't have to let people walk in with a whole camera crew and a boom mic, but you can adopt some rules, and obviously your attorneys can help you with that and what's considered reasonable. Handicapped access, if you have a physically handicapped person who wants to attend the meeting, you have to make sure it is accessible to them. And we have had that happen before where, something where the elevator was out of commission in the clubhouse and they couldn't have their meeting was usually on the second floor, couldn't do it. So that's something to be aware of as well. Compensation, a director, officer, or committee member may not directly receive any salary or compensation from the association for their performance of duties and cannot benefit financially except for the following. So it is pretty limited because, again, we don't want board members. You're not supposed to get into this for the money. Let's be real here, guys. You're doing this out of the kindness of your heart. You're not doing this for the paycheck. So that's outlined in the statute. You don't get to basically get any paycheck. So there are some exceptions. Reimbursement for out-of-pocket expenses. If your, copier goes out in the clubhouse and you got to run to Kinko's and make 1 million copies before the board meeting, and you put it on your own credit card as a board member, you could be reimbursed for that. Not a problem. If there's some sort of insurance payout, that would be fine if you were eligible for that. Otherwise, that's fine. Or really, there is authority there, any fine or any fee or compensation that's authorized in the governing documents. So we do say, in theory, your governing documents could provide that your board members get some sort of salary or some sort of, bonus for serving their community, but it would have to be in the governing documents, and it's unlikely to already have been included by the developer. It would probably be something you'd have to amend and put in there, and your owners are probably not going to support that. So good luck. And a developer or its representative, if it's one of those people who's serving on the board, they may obviously have a salary from working for the developer. It wouldn't really be related, to their work as an officer. Kickback prohibition. Again, this relates to, those fun stories that were in the news in the last couple of years. And we want to make sure that doesn't happen again. We want to make sure our board members are doing everything they're supposed to be doing. An officer, director, manager cannot solicit, offer to accept, or accept a kickback. A kickback is anything of or service of value for which consideration has not been provided for that officer, for their benefit or the benefit of an immediate family member. And we hear these allegations all the time. Hey, we're not sure what's going on. You know, we had a bunch of bids for someone to do the clubhouse roof, and lo and behold, the president just got his roof done and said he got a great deal, and that's the same vendor we're going to use for the clubhouse now. Well, that does look a little shady when you present it like that, but does it actually mean anything happened that was inappropriate? Don't know, not clear. Maybe they did get a good deal. Maybe is that considered a kickback? Don't know. We'd have to look at it, but these are all the things to be aware of. You want to make sure, again, you don't even have that appearance of impropriety there. An officer, director, or manager who knowingly violates this prohibition commits a third-degree felony. So again, not messing around with these criminal penalties anymore, guys. You know, HOA world used to be, again, a little bit the joke. It's the wild, wild west. But here, if you do the wrong thing, it could be a crime. We're not messing around. We want to make sure our board members are doing everything they're supposed to be doing and doing it properly. You're also immediately removed from the board. It creates a vacancy the rest of the board can fill. Now, there are some exceptions. An officer, director, manager can accept food to be consumed at a business meeting. So, you know, we used to do these seminars in person. We would have little snacks and all that fun stuff, coffee, cookies, all of that. That would be fine if you came and wanted to, you know, eat at a business meeting. And food or service or goods received in connection with trade fairs or educational programs. So again, if you came for our one of our classes and we gave you a stress ball and a pen, not going to be the end of the world, not considered a kickback, all right? Grounds for immediate removal. So a director or officer charged by information or indictment with any of the following crimes must be removed from office. Now, it's interesting because this is charged by information or indictment. So not convicted. You'll notice it does not require a conviction here. It's if they're charged, we want them immediately removed from office. But it is, when you hear it, again, it makes sense. These are things, if there's enough evidence there for them to be charged, we probably don't want them on the board. Forgery of a ballot envelope or voting certificate used in an election, theft or embezzlement involving association funds or property, tampering with physical evidence, again, in furtherance of another crime, obstruction of justice, any criminal violation under Chapter 720. Okay, grounds for immediate removal, out of office. The board has to fill the vacancy then. If the charges ultimately get resolved without a finding of guilt or a guilty plea or a no contest plea, then that officer can be reinstated. So if it was all a big misunderstanding and charges are dropped and, you know, no conviction, no plea, nothing, that person can get back on the board. If the criminal charge is pending, this is an interesting little, again, caveat that they put in here. If a criminal charge is pending, that person may not be appointed or elected to a position or as an officer or director of any association, cannot have access to the official records of any association, except pursuant to a court order. So if you fall into that category where you end up with these charges of, you know, forging a ballot, forging a voting certificate, embezzling association funds, whatever it is, any of those charges, then you cannot be appointed to be on the board of any association in all of Florida. Can't have access to any official records. Interesting. And again, there was some confusion, some overlap with some of these associations. If you're on the board of one, but it's a sub of another, you still sort of might have access to all these things. So the punishment is, we don't want, if there's any question that you have done any of these things that are improper and any of this wrongdoing, we don't want you on any board. We don't want you to have access to any official records until that gets resolved. Interesting. And we talked about this a little bit too, but this is just to bring it up again here. Grounds for immediate removal from the board. A director who becomes more than 90 days delinquent is deemed to have abandoned his or her seat, and it creates a vacancy to be filled by the board. Now, this is an interesting one because we talked about eligibility to run for the board. When you want to run for the board, you have to be completely current, cannot be delinquent at all, must be, you know, must have a zero balance. If you get on the board, they give you a little grace period. Kind of nice, right? So you have a 90-day window, basically. If you fall behind, you're not automatically kicked off the board. But if you become more than 90 days delinquent, and it's in the payment of anything, a fee, a fine, any monetary obligation that is owed to the association, then automatically, operation of law, you're deemed to have abandoned your seat, and it's a vacant seat. Now, this comes up a lot too. Oddly enough, comes up pretty frequently. And we'll have boards that will say, oh, we just realized when we were going through the AR that, Bill fell behind and he's more than 90 days delinquent. We really like Bill. Do we have to kick him off the board? Well, it's not really up to the rest of the board. The law is what it is, and it says he's deemed to have abandoned his seat. So if the facts are that he's more than 90 days delinquent, then he is off the board by operation of law. Done. Now, if the rest of the board says, well, we really like Bill, he's really been a great board member, wonderful. If Bill shows up with a check and he pays and he becomes current and the board wants to put him back on the board, cool, no problem, put him back on the board. He's now made up his delinquency. He's current, not a problem. If that's not quite the scenario, and maybe they say, well, we always hated Bill. He's so annoying. He's a big pain. He doesn't even help. He doesn't do anything. He just argues at every meeting. So if Bill shows up and says, well, hey guys, I brought a check. I can pay and now I'm current. So I get to be back on the board, right? I'm going to come sit at my seat up at the table there. Well, no, he was deemed to have abandoned his seat and it was a vacancy. The rest of the board can decide to fill that seat however they want. They could put Bill back on, or if they really didn't like Bill anyway, hey, sorry, Bill, we're actually going to appoint someone else. And you could put, again, whoever else. You could put John on the board. Okay. Conflict of interest disclosures. This is interesting too. This kind of goes with our whole making sure everybody's being transparent, making sure board members are doing things that they're supposed to do. This was something that, again, we kind of tweaked through the years to make sure conflicts of interest get addressed properly. If there's a conflict of interest, and let me be clear about this too, if there's a conflict of interest or something that appears to be a conflict of interest, it does not mean that you can't do it. It doesn't mean that it's off the table and proceeding is flashing red lights, can't do it, no go. It just means that you have to follow a certain procedure and you have to do it properly, or it may not be valid. And then you may run into issues. But if you do it properly and you follow the procedure and you have the board meeting you're supposed to have and everything's disclosed and everyone's being transparent, you may be able to still proceed. Now, and I'll spell it out like this. The example we usually give is, what if you are the vice president of the board? You get appointed or you get elected and you actually have the greatest, in your opinion, the greatest landscape company in all of Broward County. And you say to the board, hey guys, I don't know why we're using this other landscaper. My company can do a better job. My company will give us a better rate. Obviously, there's a financial benefit because I'm the vice president and I also own this landscape company. So that's where that conflict comes in. But my company will do a good job for our association and will save us money. So you see where just because there's a conflict, it doesn't mean it's a bad thing. It just means we got to follow, the right steps here. So any director or officer has to disclose any activity that could be reasonably construed to be a conflict at least 14 days before voting on the issue or before entering into that contract that could be subject to a conflict. So again, as long as that's disclosed, we won't have a problem. A rebuttable presumption exists only if there isn't prior disclosure. So again, disclosure is really the key here. If a director or officer or a relative of that director or officer enters into a contract for goods or services with the association, if a director or officer holds the interest in the entity that is ultimately going to enter into the contract or transaction with the association. So like I said, if it's the vice president's landscape company, or maybe it's his dad's landscaping company, we would run into this problem of, oh, there could be a conflict. Let's make sure we disclose it. Let's make sure we follow the steps we need to follow. So to proceed, to enter into that contract, because again, maybe it is the greatest landscaping company of all of Broward County, we have to disclose and essentially, again, follow these requirements. That proposed contract has to be fully disclosed to the board. Disclosure has to be referenced in the minutes of the meeting. and this is where it is actually a special requirement, the owners or the board members are going to vote, it has to be approved by 2/3 of the directors present. So not the usual quorum, 2/3 of the directors present. The board member who has the conflict, that vice president, he doesn't get to vote. He doesn't vote on that because obviously he takes a step back. He has a conflict. He's not voting. Everyone else on the board votes. You need 2/3 to approve it. The contract has to be reasonable and fair to the association. I would assume it would be already, but that's one of the requirements. And at the next regular or special members meeting, the existence of that contract is supposed to be disclosed to the membership. That one is a little funky only because you probably only have a membership meeting once a year, and it might only be a year-long contract with the landscape company or with that vendor, or it could be done already, but you still have to disclose it. Now, upon a member's motion, the contract could be canceled by a majority vote of the members present at the meeting. If the members cancel that contract, the association's only liable for the reasonable value of the goods or services up to that time of cancellation. There's no penalty, termination fee, liquidated damages, any of that for cancellation. That's all out the window. Doesn't come up much because the owners don't generally know they have that ability, but could happen, something you should be aware of. All right. Official records. All right. Official records are not fun, but they're trying to make this easier and more convenient for everybody, and it just seems to be somehow getting more complicated and confusing for everyone. But hopefully you guys know you have certain official records when you're on a board. You have to keep all of these records and documents. They have to be available to your owners. There's a whole list here. I won't read the whole list, but basically it's everything you think it is. All of your governing documents, copies of your policies, minutes, roster, all of that. The last thing here that they list is all other written records of the association that are not specifically identified, which are related to the operation of the association. That's a bit of a catch-all. Basically, any written record that deals with the association, with the operation of the association, you should assume it's part of your official records and you need to hold on to it. Now, there are certain exceptions, ballots, sign-in sheets, anything to do with a vote, you only have to hold on to for 1 year. So that's kind of nice. Most of your other official records, though, you have to hold on to for at least 7 years. Okay. Bids, you only have to hold on to those for a year. The association is actually supposed to adopt written rules regarding the method, policy of how they are essentially keeping their official records. That was supposed to be done last year. Most associations have done it. And also that information has to be available to the owners on your website if you have a website. There are certain official records that the association has to have, has to keep, has to protect, has to maintain, but are not going to be open to your owners. So some of these are obvious. Any records protected by attorney-client or work product privilege, those are not open to your owners. So the association has to hold on to them because they're part of the official records. But when we're doing an inspection and making records available to your owners, these are the things they cannot see. You cannot let them, have access to. So attorney-client privilege, work product privilege, any information obtained in connection with the approval of a lease, sale, or transfer of a parcel. Now that's meant to really target, any background checks, credit checks, things like that. And it kind of makes sense. If you're running that, if you're doing approvals of leases and sales, that's not information that every owner needs to be, viewing. Information obtained in a gated community in connection with guest visits to owners or other residents. That was something they added a couple years ago. That's information that, again, other people don't necessarily need to have access to. Social security numbers, driver's license numbers. If you're a 55 and over community, and hopefully this is not the first time you're hearing this either. If you're a 55 and over community, you're supposed to be doing regular surveys. So every 2 years, surveys so that you know who's in your community, who the occupants are, who's residing there, so that you keep your 55 and over status, basically. If that's the case, you probably do have a lot of photocopies of driver's license numbers or driver's licenses, IDs, all that stuff. You may also have those things if you're not a 55 and over, because maybe you did it as part of the lease sale approval or whatever else. But driver's license numbers, that's not open for inspection. You would have to redact that if that appears on something. Credit card numbers, any other personal identifying information. Now, if that somehow gets leaked, you're not, you, the association, are not responsible for that. but that's information that owners don't need to have. Personnel records, that's interesting because there is a distinction here. Personnel record, when we talk about maybe your maintenance guy who got written up because somebody complained that he was rude to them or something. That may be in a report. He may have a file. That's one thing. Now, that's different than a management agreement, or your employee agreement with that individual. Any agreement that spells out what the association is paying to someone is probably open for inspection because they want to know where the money's going, and your owners are allowed to know where the money's going. But personnel records, if you have something, you might have something even more sensitive, their tax information, their medical information. That's not something that your owners need to see, but an actual employee contract would be open for inspection. Medical records of your owners or residents. If you're a community where maybe somebody made a reasonable accommodation request to keep an emotional support animal, and they sent you medical records of why they get to have, they have PTSD, this animal helps them, and here's a note from my doctor, so I get to have a 150-pound, giant dog in our community. That is something you have to deal with separately, and we have classes on fair housing stuff, so we won't get into that. We won't go onto that tangent today, but that's an interesting topic. But that may be where you would have medical records. That's, again, you would keep it in your official records, but it's not open for your other owners. Any security measures, passwords, things like that, not open for your members. Any attorney-client privilege, we talked about that. It gives you a little definition there. Membership directories, we get questions about this. Can we publish a directory? What are we allowed to let owners see? What aren't we allowed to let them see? You can distribute a directory that contains the names, lot address, and telephone numbers of your owners. We would tell you the owners should be able to opt out and tell you they don't want their telephone number included if they send you something in writing. They can also consent to have other information put in there if they wanted to. Sure. Providing rules and covenants. This was something else they added last year. An association is supposed to provide a physical or digital copy of the association's rules and covenants to every member. That was supposed to happen by October 1st of last year. The association has to provide a physical or digital copy of the rules to every new member. So whenever anyone comes in, buys in, they're supposed to get a copy of the rules, copy of the covenants. If those are ever amended at any point in time, the association has to send an updated copy to everyone. You can comply with this requirement by posting a complete copy on your website, if you have the website, or direct link thereto on the homepage of the website. So that's something that might make your life a little bit easier. Instead of having to do a giant mail out, you could put it on your website, and your owners would have access to it there. Access to official records. This is always the question. So your records have to be made available for your owners to access them. That is the whole point. You're keeping these official records. Your owners get to see what the association's up to. They get to see the expenses. They get to see all this fun stuff and kind of keep an eye on our boards and our management teams and see what's going on. Access to records has to be within 45 miles of the community or within the county in which the association is located. That's where the records need to be kept. Within 10 business days, you have to provide the access after receipt of the owner's written request. So 10 business days, that's it. That's the window. It's not long, but it is business days. So if you get a written request to inspect the records or for access to the records, you have to give them access, at least offer one appointment that's within those 10 business days. Hey, we have those records. You can come to the office, whatever, next Friday at 3 p.m. if you'd like. The association can have the records available, a copy of the records available. You can make them available electronically via the internet. Oh, you asked to see, the minutes of every meeting from last year. Great. We have the minutes on our website. You can go there. You can look at them. Or here's the thumb drive for all the records you asked to see. Now, it is easier if you can just make access available. Hey, come into the office and see what you want to see and get a copy of whatever it is. That's one way to do it. But now they do allow you to actually make them available via the internet or on an electronic format. If the request is submitted by certified mail, and the access is not provided within that 10 business days, there's a rebuttable presumption that the association willfully failed to comply. So again, we're not messing around with records requests either. If you get anything that appears to be a records request, talk to your counsel, get with your management team, make sure you respond timely, make sure you make an appointment available, or you send the records or give them access to the records within that time frame. A member who's denied access is entitled to actual damages or minimum damages. The minimum damages are $50 per calendar day up to 10 days. $50 up to 10 days. So $500. Your owners might sue you over $500. We've seen it happen. And then all of a sudden they get attorneys and that number keeps going and keeps going, keeps going. And now you're just fighting over attorney's fees. So make sure you respond timely if you get a request to inspect the records. This was also a funny one. This had to do with the things we talked about before, those lovely scandals that were in the news. Last year, they put this in the law. If the association receives a subpoena from law enforcement, the association must provide a copy of those records or make those records available within 5 business days. So they shorten the time. If you get a subpoena from law enforcement, you have 5 business days. All right. And you must assist law enforcement to the extent permissible by law. Okay. Hopefully that doesn't apply to any of you guys. Official record crimes. We talked about some of this stuff already, but it's reiterated in this official records section as well. In Chapter 720, again, things that we already had issues with, fraud, embezzling, all of that. Now we've kind of worked it into official records because they thought that there were crimes associated with kind of hiding your tracks, so to speak. So I don't love this, but there are now crimes associated with not properly dealing with records requests. A director or manager who knowingly, willfully, and repeatedly, so 2 or more times in a 12-month period, fails to provide access to the records with the intent of causing harm to the association. So now we've added intent, commits a second-degree misdemeanor. So you got to be really careful, guys, and make sure you, again, are responding timely. A person who knowingly and intentionally defaces or destroys accounting records with the intent of causing harm to the association commits a first-degree misdemeanor. A person who knowingly, willingly refuses to release or otherwise produce association records with the intent to avoid or escape detection, arrest, trial, or punishment, or to assist another person in that effort commits a third-degree felony. So again, lots of crimes now that are worked into this because of those scandals in the last couple of years. Official record rules. You can adopt rules into how you're handling these official records requests. Talk to your counsel. Make sure that the rules you adopt are considered reasonable. Your attorneys can help guide you with that. But you can adopt reasonable rules governing the frequency, time, location, notice, records, and the manner of inspections. Because without fail, you're going to tell me probably you have one owner who is a giant pain and they always want to do a records inspection. They're always asking management, hey, can I come in and inspect the records? Can I come in? I want to see the minutes from the October 1st meeting. And then a week later, oh, I want to see those minutes again. Oh, can I see the minutes from the January 1st meeting? You may have those owners who just sort of end up being a thorn in the side of your manager. And your manager can't get anything done because they're busy handling that one person's, official records requests. You can adopt rules to sort of limit that or help reduce the time your management team is going to have to spend on those things. You cannot require that an owner show any proper purpose for their inspection. You don't get to say, well, I don't know why they want to see the minutes, so I'm not going to give them to them. That doesn't work. Doesn't matter why they want to see it. They get to see it. You can't ask. Doesn't matter anyway. You can't require that an owner state any reason for the inspection, and you can't limit the right to inspect to less than 1 8-hour business day per month. And that's one that we run into a lot where people will say, well, I can't have the manager there all day sitting there and just babysitting this person in the office. Well, you might have to. You have to give them at least that opportunity. You could break it up. You could adopt some rules, maybe a 4-hour appointment and then another 4-hour appointment. But you can't say, I'm only going to give them 30 minutes to look through the records and that's it. And we have other things to do and too bad. Not going to work, not going to fly. So talk to your counsel, adopt some rules if official records and inspections are becoming a thorn in your side. Copying records and the fees associated with that. You can actually use a portable device. The owners can come in, they can bring their own scanner, they can even just use their phone and take a picture if they want of the records. You can't charge if they do it that way because you didn't do anything. It's not, you didn't make a copy. They can take a picture, they can use their technology, and that's free. Okay. If the association has a copy machine and you're going to make the copies there, that's fine. You can do that. If the request is limited to no more than 25 pages, you can charge up to 25 cents per page. If you don't have a copier, or if it's going to be more than those 25 pages, you can send it out. You can use an outside company, and then you would charge the owner, the actual cost that you incurred to make those copies. So you would have them maybe flag each page that they want to see. It ends up being 50 pages. Great. We got to send it out to whatever copy service. Maybe that copy service charges you $50. Great. Then you can tell that person, I need you to pay us this $50 for this $50 invoice, whatever it might be, but you're charging the actual cost. You can't upcharge it. You can't say you get, an extra anything. Personnel costs, that's the biggest complaint. Our manager, again, has to sit here all day and they can't do what they need to do. Well, there's a little bit of leeway here, I guess I should say. If the time spent to copy the records exceeds 1/2 hour, and if the personnel costs, you can charge them, but they're capped at $20 per hour. Okay. Personnel costs can't be charged if it's going to end up that they've copied 25 or fewer pages. So again, there's some complications there. This is not meant to be a money-making thing for the association by any stretch of the imagination. And I know you're going to complain, but it costs us administrative fees and time and hours of our manager to deal with it. So, like I said, talk to your counsel, adopt some rules, and see what you can do to kind of limit your official records inspections. Association website, we talked about this. 100 or more parcels, you should already have it. Has to be accessible through the internet. The association has to provide the owners with a username and password so that they can see all of the protected sections. You don't want all of your documents open to the entire world. You want the documents available to your owners, not to all of the internet. So you need a username and password so that you can put things behind behind that secure wall or whatever it is. The documents that are required to be on your website are different than your official records list. Again, I won't read them all to you, but you don't have to put all of your official records on the website yet, at least. They don't quite exactly sync up. So, but the more you have on your website, probably the easier your life's going to be if your owners want access to the official records. But look here, this is the list for your what's required to be on your website. Notices, those all have to be posted. Like we said, we've talked about that. The association also has to make sure that any of the information that's not open for owners is not posted on the website. That makes sense, right? So everything that's closed to, for an inspection that's not accessible, anything that's attorney-client privileged, or again, those, if you have social security numbers, if you have whatever else you might have that is not open for inspection, cannot be on the website. Makes sense. If any protected information ends up on there or is included in documents that you're putting on your website, then it should be redacted. You're really not going to get in trouble unless that disclosure was made knowingly or intentionally and you've disregarded and put that information out there. To amend your governing documents, hot topic. We do have a class just on this where I talk about amending our governing documents for a solid hour. We won't do that today, but we'll just touch on it a little bit. And we know the deal. Your governing documents were drafted by your developer, probably, 25, 30 years ago now, at least, if not 50, 60 years ago. Your developer did not really, and don't take this the wrong way, they didn't really care about you so much. They don't care about you as an owner. They don't care about who actually lives in the community and what that means for the people who are there. For the most part, they cared about having people buy in the community, having lenders want to lend in the community, and they just wanted to sell and be done and set you guys up, and they wanted to go on their merry way. Your documents might not reflect how you actually function as a community anymore. They may not make any sense. They might be completely outdated. They might be missing a lot of stuff that's changed in the last, again, 30, 50, 60 years. You may want to amend your governing documents to bring them up to date and or to make more sense for your community. That's fine. Look at your governing documents, look at each one, because we said you have different governing documents, right? You have a declaration, you have articles, you have bylaws. Look at each one of those things and see what the threshold is to amend them. You might be able to amend your bylaws by just a board vote. Sometimes that happens, but typically your amendments are going to be spelled out in your governing documents. To amend this declaration, it requires a vote of no less than X number of owners or X percentage of owners. If there's nothing in your governing documents, the default is 2/3 of your voting interests. You may have old language that says 75% of your voting interests. If that's the case, the first thing you might want to do is just amend the 75 and get that down to a majority maybe. Talk to your attorney, see if that's something that makes sense for you before you spend money drafting all these lovely amendments. And again, happy to do it for you, but I'm going to tell you, if you have a threshold that's really high, if you have 75%, change that first. Don't spend money drafting 1,000 new amendments if you need 75% of your owners to approve any of them. First amend that, bring that down to a more, achievable number, 50, a majority, whatever it is, and see if you can get that in place first. Amendments have a very specific way of how they have to be done. We underline when we're adding language, we strike out when we're removing language. If you're completely rewriting essentially a section, there's language you have to put in there. See governing documents for current text. There is a whole procedure. There's a whole procedure that has to do with lender consent. A lot of declarations will have language in there that you can't change something without the lenders also agreeing to it. If that's the case, you might need mortgagee consent. The statute actually allows you to do it through a mail out procedure. Talk to your counsel about that. Your amendment to your governing documents, if you successfully get it to pass and you get enough owners to agree and you do it at a meeting or however you do it, that amendment actually doesn't become effective until it's recorded in the public records, which now you can e-record most of these things. You can make them effective pretty quickly because now that turnaround time is, as quickly as you can get it recorded. That's nice, but there is some confusion because sometimes there's a little bit of a disconnect. Hey, everyone approved this amendment last week, and so we have an owner who wants to buy. Do we get to now say that we're going to impose our new sale and lease procedure? Well, no, it's not effective yet. You didn't get it recorded yet. So you need to make sure as soon as you have your membership vote and you get enough votes and the amendment has passed, get with your counsel, get it recorded, ASAP, because you want it to be effective. Within 30 days after recording that amendment, you have to provide a copy of the amendment to your owners, or if the owners all got a copy before and nothing changed, that's fine. Then you just have to notify your owners that it is now recorded and they can go look at it in the public records if they'd like. You give them the instrument number just so they are aware that you have a new provision in the governing documents. Few topics we're going to touch on. These are all things you guys should know about. We'll get into them. They're kind of random. It's a little bit of a miscellaneous category here, but we'll get into all this stuff. Governmental filings. You have to do at least 2 governmental filings a year. Division of corporations. That's basically SunBiz. If you guys have heard that, to maintain your active corporate status, you have to file an annual report. There is a deadline to do it. If you're late, they charge you a fee. They charge you an extra fee, a late fee, all that good stuff, but make sure you do it. Make sure you stay active. You have annual income tax. You are not for profit, but you're not exempt from filing income taxes. Get with your accountants, and you may actually have some sort of income. You might have, estoppel fees. You might have a laundry lease. You might have a lease with cell towers where you're getting payment every year or whatever it is to lease your cell tower space. All of those things need to be reported to your accountants so you can make sure you're doing your taxes the way you're supposed to. Meeting minutes. Meeting minutes are, for some reason, a little tricky for people. They are not probably what you're thinking. You're not court reporters. You're not supposed to be doing a full transcript. You're not supposed to put every detail of, Joe raised his hand. He called Mary an idiot. Joe said we should not proceed with this project. Joe said he likes the other project better, blah, blah. You don't need to get into nitty-gritty details of the minutes. You need to take minutes, but your minutes are supposed to reflect the actions taken, the attendance at the meeting, who made a motion, who seconded a motion, what the votes were in favor or not in favor. You could indicate that there was discussion about a motion. You don't need to, like I said, have a full transcript of everybody who said everything about, about the topic. Material alterations. This is something that comes up usually more in the context of condominiums, but it is an important one because it could come up in your world as well. What's a material alteration? And this is kind of a crazy definition, and I will not cliff notes this one for you. I'll read it to you because you can realize how kind of crazy it is that we have to deal with this as well. This is the definition. It came out of a condo case, but this is what we use when we determine if something's a material alteration. It is essentially a material alteration means to palpably or perceptibly vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. It's a lot of words, a lot of flowery, fluffy sounding words. Basically, the gist is a material alteration is, are you altering something in the common areas, in the world of condominiums, in the common elements, that really does make a big difference that might require a membership vote. So the case that we always talk about is the seawall case. It had to do with condominiums, obviously. Seawall was crumbling. Seawall needed to be replaced. Obviously, there's a safety factor there. If the seawall crumbles, there's a problem for the association. But association had to adopt a special assessment to pay for that project. There was a challenge. The vote, they never got a vote. The documents required a vote for a material alteration, and they modified the seawall, so it needed a vote, blah, 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 blah. I shouldn't have to pay the special assessment because of that. That was the argument. Luckily, the ultimate result was, wait a minute, we actually used some logic here. The ultimate result was that was necessary maintenance. That was a necessary repair item. It had to be done. Obviously, we want the seawall to be fixed. We can't let the seawall crumble into the water. The special assessment is valid. The procedure was valid, even though they didn't get the vote that they needed to get. And now the case law is you don't have to get a vote, even if your documents otherwise require it, if you're doing necessary maintenance, if you're doing a necessary repair that the association is responsible to do. So it has to be, in this case, common area, common element. That's something that the association has to do. They don't need to get a membership vote if their documents would otherwise require it. In the world of HOAs, you guys probably don't have language in your governing documents that requires a membership vote for a material alteration, but you might. There could be something in there that says the board doesn't, the board can't spend more than 10% of the annual budget or more than $50,000 without a membership vote or without approval of the members. Something like that, for a special project or for a capital improvement. There might be some language. So if you're doing any projects that require spending money, that require making changes to the common area, if you're thinking of, knocking down your clubhouse because you want to put up 12 new pickleball courts, check with your counsel, make sure that's something you can do without a membership vote. That's the key. Are we going to need a membership vote for this, or is this something the board can do on its own? That's what you want to look at. Rules and regulations, this is important too. You guys generally have the authority to adopt some rules. Question is going to be, are they enforceable? What makes them enforceable? Look at your governing documents, make sure you do have that authority. Do you have the authority as a board to adopt rules only about use of the common areas, or do you have the authority to review or to adopt rules about parcel use? Could you adopt a rule that has to do with a lot, or can you only adopt rules about maybe, clubhouse use or parking in the clubhouse? Those are all things you'd have to look at your governing documents, see what your authority is. You also can't have rules that conflict with what's already in your declaration. So if you had a rule that said, no trucks in the community, but your declaration doesn't say anything about trucks, you might have a problem there because now they conflict. Or if your declaration says no trucks, and then you have a rule that you just sort of want to clarify what's in your declaration, or you adopt a rule that says, we did mean no trucks, but no trucks actually does mean only commercial vehicles, only, trucks over X size, only X tonnage, whatever it is. We didn't mean, SUVs. Those are fine. That's okay. When we said no trucks, we don't mean that. We don't mean, you can't bring your Yukon or your Tahoe. We mean you can't bring your Dodge Ram. You can't bring that kind of thing. That's fine. If you adopt rules where they're clarifying what's in your declaration, that should be enforceable. You should be okay. But if you're adopting rules that conflict with your declaration, that's where you're going to run into a problem. So if you're considering any rules, adopting any rules, again, it's trickier than it sounds, and you want to make sure they're going to be enforceable. Talk to your counsel, get them, reviewed before you do anything. Marketable Record Title Act. Okay. You may hear this abbreviated as MARTA, depending on, which attorney you're talking to. I say MARTA. MARTA makes me think of the transit system in Atlanta, so I say MARTA. 30 years from the time, essentially from the root of title, your covenants expire. This may be a record-breaking piece of information that I am dropping on you right now. 30 years, your covenants expire. Okay. Statute says that. It's in chapter 712. It's a different statute. It's also referenced in 720, but specifically it's in 712. The thinking was we don't want all of these covenants sort of encumbering title and staying on the land and running with the land if they're old and if no one cares about them anymore. And we want to be able to sell land without these covenants still encumbering them. That was the thinking of where this comes from. Now, the problem is that may mean when we talk about covenants that run with the land, your declaration of covenants, that's what it is. It's covenants that run with your land. So your declaration, your covenants may expire after 30 years from the date it's recorded. There are ways to preserve your covenants. It's not the end of the world. But if you are a community where your declaration is within 30 years old, talk to your attorneys because you want to make sure you preserve it and you can extend the life of your declaration and your covenants without having to make this process more complicated. Talk to your attorneys now. If you're already past 30 years, make sure you either did preserve them or talk to your attorneys about possibly having to revitalize your governing documents. That's much more complicated. That involves getting your owners to all vote, getting a majority of your owners to sign off. And it's a whole procedure, and you have to send it off to the state and Department of Commerce, and they check your documents. They check that you got enough votes, and it's very time consuming. If you're within the 30 years, it's a board vote and it's a board preservation, and it's much easier to accomplish. So if you're within that 30-year window, talk to your attorneys, see where you are, get it done. If you're outside of 30 years, hopefully there's a preservation already recorded. If not, talk to your attorneys and make sure you get your documents revitalized. The problem is if your covenants expire, your covenants are the promises that everyone made when they moved in to pay. It's probably your lien. It includes your lien rights as the association. It includes your ability to enforce any violation. You're not going to be able to tell a homeowner that they can't paint their house, pink and purple anymore, because guess what? Your ARC authority is out the window because your covenant expired. So these are things to be aware of. Talk to your attorneys. Look at how old your documents are. That 30-year mark is very important, okay? Emergency powers, we won't get into this too much. It's in here, you have it. Basically, they changed the statutes in the last couple of years to clarify the emergency powers that the association has. If that's fine. Takes up a couple slides here. Debit cards, this was an interesting, rather specific item they added to the statute. An association directors, their agents cannot use a debit card in the name of the association or bill directly to the association for the payment of any association expenses. Person who uses a debit card for an expense that is not a lawful obligation of the association commits theft. So again, crimes are sprinkled throughout the statute now. You want to be very careful you don't run yourself into one of these problems. A lawful obligation of the association means something that was pre-approved. So the board can't even retroactively say, oh, we told Mary to go ahead and use our credit card or use a debit card for that expense. And that's okay. And the board's okay with it. And we're signing off and we're good. It has to have been pre-approved. So be very careful. Basically, bottom line, do not use a debit card, period. Full stop. Debit card is a no, okay? Litigation authority. This is an interesting one. We've seen this come up where communities are considering maybe suing a developer. It would have to be a serious lawsuit because ultimately it involves an amount in controversy over $100,000. If that's the case, if the board is considering a lawsuit where the amount is going to be over $100,000, the association actually needs to get a majority of the owners who are present at a meeting at which quorum is obtained to vote in favor to support that lawsuit. Otherwise, that's something the board can't do on its own. That's only in HOAs. Architectural control. This is something that's been a hot topic in the last couple of years as well. So you want to make sure you're not just, denying people's ARC applications if you don't have the proper authority to do so. Now the association is supposed to act reasonably, equitably, enforce all of their architectural guidelines. We're going to tell you in general, if you are an association that reviews any ARC requests, if you have whatever we're calling it, ARC, ARF, architectural controls, whatever it is, if you have a committee, the board does it. If you're reviewing anything that's architectural related and the documents allow the association to approve or disapprove, again, whether it's you or the committee, to approve or disapprove some sort of modification to a lot, make sure you actually have guidelines in place. Make sure the board has adopted specifications and guidelines. If you tell someone, no, they can't put that fence up in the backyard, you're going to need to be able to answer, why can't they put that fence up? Do the documents say no fences? Great. Do the documents say fences only if allowed by the board? Well, that doesn't tell me what kind of fences. Do you then have specifications that say, oh, we do allow fences, but we only allow not taller than 6 feet, and they have to be the white PVC fence. And you were proposing to put in a wood shadow box fence. So we don't approve those. We only allow white PVC fences. Great. If you have specifications and you have guidelines that you can point to as a board or as a committee where you can say, these are the only fences we approve, or these are the fences we don't approve, problem solved. You're not going to run into an issue. If you don't have that, and you just have in your mind, well, we've only ever approved PVC fences, that's not enough for an owner to know that they can't put up the wood shadow box fence. You have to adopt these guidelines. You have to publish them. They should be in writing. Talk to your counsel. Make sure, it's going to come up when you're not even thinking about it. And you're going to get an owner who asks you to do something that you're going to want to say no. And you're going to have a problem if you don't have a reason and something you can point to explain why it's a no. All right. So the latest is, and they actually did put it in the statute, if the association denies an owner's request for the construction of a structure, another improvement on the parcel, they must provide written notice stating with specificity the rule or covenant that the association relied on to deny the request and the specific aspect or part of that improvement that doesn't conform. So again, you can't just go back to the person and say, application was denied, the end. That's not going to cut it anymore. Now you have to be able to say, your application for a fence was denied because you asked for a wood shadow box fence and our specifications say we only allow PVC fences. Something along those lines. You have to have the guideline. You have to have the specification. You have to have a reason. You can't just go with your gut. Well, we don't like that fence, so we said no. Not going to fly anymore, okay? You can't enforce a covenant rule or guideline that places requirements in the interior of a structure that's not visible from the parcel's frontage or an adjacent parcel or a golf course or a community common area. That was new. Now, if there's something where you get to approve some sort of AC, refrigeration, ventilation, again, if it's not visible from the parcel's frontage or an adjacent parcel, then too bad. So you're not going to be able to enforce those things. Now, again, there's an argument, well, we can because our covenants say we can, and there's a Kaufman argument, and doesn't apply to us because it's a new statute. There's a whole discussion there. We're going to get into it on this item or this slide. Items on a parcel. Regardless of any covenants, and unless prohibited by general law or local ordinance, an association cannot restrict owners or their tenants from installing, displaying, or storing any items on a parcel which are not visible from a parcel's frontage or an adjacent parcel, an adjacent common area, they did add that in, or a community golf course, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. Now, I will tell you, the scuttlebutt in our in our area of practice was essentially there was someone who wanted to keep a boat in his backyard, and his HOA's restrictions were you can't keep boats in your backyard or anywhere on the property. And so he pushed the legislature to say, well, but it's in my backyard and nobody can see it. So what's the problem? Basically, leave me alone. Let me keep my boat in my backyard where no one can see it. So now we have this lovely statute. So the gist is, if you have a covenant or restriction that prohibits certain items from being stored, kept, installed on a parcel, but essentially they're in the backyard, so to speak. So they're not visible from the front. They're not visible from a neighboring parcel, or a golf course, or maybe a common area that's adjacent from the back. Maybe the property abuts a lake and you can see into the backyard from the lake. If that's the story, if you can't see from any of the surrounding areas, basically the backyard is sort of a free-for-all. You can't now restrict what they're doing back there. You can't enforce your covenant that says no boats to be stored, no vegetable gardens, no artificial turf, no RVs. Now, again, how this is really enforced is kind of interesting because it gets a little dicey. We have communities that are HOAs, but they're townhomes. And now you can see it, but only if you're on the third story of the neighboring community or the neighboring parcel. Does that count? Is that what they meant? Maybe, probably. What if the neighbor just puts really, really, really tall hedges up and now you can't see into their backyard because they put super tall hedges up? Does that count? Can we enforce? Can we not enforce? All of these scenarios that now come up thanks to this lovely change in the statute. And again, there's an argument to be made. Well, but you said regardless of any covenants, but we had this covenant before you changed the statute, and we think it's a substantive right, and we should be able to enforce our covenant, and we don't have Kaufman language, so we don't change with the statute. So we think our, year 2000 version of 720 applies, and we're going to ignore this version of the statute. That's another argument. Talk to your counsel, see sort of where you fall. Hurricane protection, this was added into the statute last year too. The association should have hurricane protection specs for each structure, roof systems, storm shutters, all that good stuff. You should adopt all of that. Vehicle restrictions, this is another one where we get into this whole Kaufman discussion again. This was something that came up last year, and it's been a hot topic ever since. The association's governing documents can't prohibit essentially an owner or his tenant or a guest from parking their personal vehicle, which would include a pickup truck, in the driveway or any other area that they have a right to park. That's now in the statute. Now, owner, guest, whoever has to be able to prohibit or cannot be prohibited from parking their work vehicle either. Work vehicle is meant to address any of those commercial vehicles, maybe a plumbing van or handyman van or whatever it is, or truck or something. Now, if that's someone's work vehicle, they have to be able to park it in the driveway. Now, and then there's restrictions. You can't have certain commercial vehicles. You can't have, a huge 18-wheeler truck, something like that. So the thinking behind this was we want to allow owners to be able to park their own vehicles in their own driveway. So we're going to say that the association cannot enforce their covenants if their covenant says no trucks, if their covenants say no commercial vehicles. Because again, if you're the owner of, John's Plumbing and you want to park your John's Plumbing truck in your own driveway, the thinking was you should be able to. Okay. Now, again, this gets us more into this complicated analysis of, but I bought in a community that had this covenant that there were no trucks and there were no commercial vehicles allowed to be parked in driveways. They only can be in the garages if they're, in our community at all. And that's a substantive right. And I want to be able to enforce that covenant. And my documents don't follow the statute because they don't have Kaufman language. So my, again, declaration says no trucks, no commercial vehicles. And I should be able to follow the law that was in place in, 20 years ago and not this new version. That's another legal argument. That's something you should talk to your attorneys about. But that seems to be what everyone's kind of following right now. We haven't had a case actually come up with it yet, but that's the argument. The statute says governing documents can't prohibit trucks and commercial vehicles essentially from being parked in driveways. But there is an argument, but the statute doesn't apply to us, depending on your governing documents. So talk to your counsel before we get into any of that. Contractor restrictions, this was another one added last year. Essentially, you can't prohibit an owner from having a contractor access their property or come into the community just because they're not on your preferred vendor list. The association can't require them to show some sort of occupational license to come into the community. If they're coming in, they can come in. Budgets and reserves, we'll get into this a little bit. We're kind of at the tail end of the budget season here, because hopefully you've adopted your budget by now and we know what we're working with for January, but not always. I'm actually going to a budget meeting tomorrow, so I know people are still working on it now. But your annual budget should not be that complicated. Essentially, you're supposed to use last year's budget as your guideline, use it as an estimate, and then adjust sort of accordingly. If you know that you found a cheaper vendor for whatever it was, landscaping, or this one project is over and you can adjust accordingly. Or hey, we are going to have to spend more money on this next year. That's it. Adjust your budget. It's not, set in stone. You're okay. It has two components, essentially your operating expenses and your reserves, if any. Talk to your accountants, talk to your attorneys if you have questions about reserves. But ultimately, again, it's a rough estimate from what you did last year. Your operating expenses, that's your day-to-day stuff. That's paying your taxes, paying your management, paying your, the maintenance guy, paying the landscaper, paying your attorney, all of those fun things. Now, all of those get listed as line items on your budget, but ultimately those dollars can be used for any of those categories if you needed to. You're not locked into them as line items. Reserves are a little different now. So reserves, you may not have reserves at all. If you're an HOA, it's quite possible you don't have reserves. It would depend on if your reserves are set up in your governing documents or if the members decided to do it. But essentially, your reserves are typically for something that is a bigger ticket item that's going to take longer to complete. If it's a repair project, so something greater than a year, a capital expenditure, deferred maintenance, all of those things. Really, that's probably your pavement, maybe your clubhouse roof, something like that, sidewalks, things of those natures. Then maybe you have reserves for those. But again, you don't have to necessarily. It would depend on your community and what you've done and what the developer has done. A majority of your total voting interests might have voted to create reserve accounts, and maybe now you're funding those reserve accounts that the owners approved and that the owners established by a vote. If that's the case, then you have to fund them every year. Those are statutory reserves. They have to be funded once they're set up, or maybe your developer put in your governing documents that you were going to have reserves and you're going to be reserving every year for, again, whatever, the clubhouse roof. If they are not set up that way, if it's just that the board decided one day we'd like to start kind of a contingency fund, we'd like to start a slush fund, we know one day we're going to have to repave the streets, we might as well start saving now. If it's a board established reserve account, we would tell you don't call it a reserve account because you're just going to confuse things. If it's a statutorily created reserve, so your developer did it or your members voted on it, that's different than the board decided that they would set it up. If there's confusion there, again, talk to your counsel. Calculating reserves, generally, you're going to do an analysis of what the remaining useful life is. You back it out. You do the math of we have 10 years left, $100,000 to redo the roof. So we know we need $10,000 a year or whatever it is. You can have pooled reserves. You can have individual line reserves. Pooled reserves essentially just mean, hey, we're going to put all of the items together in one pot, and we can use the money for any of those things. You could do individual line items, but the flexibility of a pool is a little bit easier and generally preferred by a lot of people. To waive or partially fund reserves, again, this is only if the developer or your owners decided to set it up. It's only if those are statutory reserves. Then you have to have a membership vote to not fund it, basically, to reduce what you're funding, to waive or to partially fund those reserves. You're going to need a membership vote. If it's just the board that set it up as a slush fund, then it's a board decision. You don't need a membership vote. This is why we said don't call it a reserve account if the board decides to do it, because you're just going to confuse yourselves down the road. To adopt a budget, this is another sort of a difference in condo HOA world. In condo world, there's a specific requirement when you mail out your budget, how many days and the notice and all of that. That's not the case in HOA land. 720 doesn't address it. So ultimately, you have to look at your governing documents. If your governing documents say you're having a special meeting, then you follow those governing documents. You follow that notice requirement. If there's nothing in there, guess what? Your budget meeting is just a meeting of the board. So it's a 48-hour noticed meeting. That's it. Okay. Oh, all right. Oh, and also as part of that, you're not required to mail out the budget before the meeting unless your documents say you have to. But we do say generally you should consider sending it to all your owners and give them time so that you have your owners actually involved and keep them posted on what's going on. Assessments and foreclosures. All right. So special assessments, we talked about these a little bit. Special assessment is essentially when your budget is short. You have a, extra project, or you weren't expecting to have to do the, clubhouse roof so quickly, and here we are, we need a new clubhouse roof, or insurance won't insure us. So we got to do it now, and we need the money now, essentially. Or maybe you didn't budget properly and there's a shortfall. So if you need a special assessment, typically it's a board vote. You look at your documents, make sure there's no ownership approval needed. But if it's necessary maintenance, if it's a necessary maintenance item, remember the seawall case from the condo world that applies to you here. If it's a necessary maintenance item, you wouldn't need a membership vote. But check to see what your governing documents say. It's going to be a 14-day notice. The notice has to indicate what that special assessment is for and how much it's going to be, roughly, estimated cost. And 14-day notice, not 48-hour, even though it's a board meeting, 14-day, okay? And a special assessment, by the way, is collected in the same manner as a regular assessment, just so we know. So, your owners, if they don't pay the special, you can still move them into foreclosure, you can collect, you can file a claim of lien, you can foreclose, you can take their property away. Requirement to provide an accounting. This was an interesting change they added to the statute last year too. Basically, a parcel owner can request to get an accounting of their account, essentially. So they can request to know what their balance is, what an updated ledger is, all of that. The board has to respond within 15 business days. And that owner now can't ask again for another 90 calendar days. So it's not quite an estoppel, but it's an owner accounting. And then once you comply and you give it to them, they can't ask you again for 90 calendar days. So, but there is a penalty. If you don't respond, it's a complete waiver of any outstanding fines they might have. So the penalty is, we're not going to say they don't owe anything, and maybe they owe a bunch of assessments and you wouldn't want to wipe that clean. But the punishment's going to be if there are any fines on that ledger or fines on that account, the fines are going to get wiped out. Because we know fines are sort of, that's bonus money. That's house money. That's not anything you guys are really owed in terms of, to conduct your business and to operate. So we're not going to wipe out assessments. We know the associations need assessments, but we'll wipe out fines if you don't comply and you don't send that accounting timely. Collection of assessments. Your assessments are going to bear interest at the rate indicated in the deck or in the bylaws. If there's nothing, it's 18%. That's the highest you're allowed to go. Compound interest may not accrue, but you can charge interest. You can charge late fees. Late fees are the greater of $25 or 5% of each installment. Again, that has to be in your governing documents. So make sure your governing documents are up to date because, again, you don't want to leave money on the table, right? Any past due assessment, you can charge interest and late fees as long as it's in your governing documents. You're also entitled to collect attorney's fees or any collection cost, essentially, on delinquent assessments, okay? Statute outlines how payments are to be applied. So if someone, writes you a check and says this is for, August's assessments, but they're actually behind, and there's late fees, and there's interest, and there's other payments that were missed, and there's attorney's fees, it's not applied just because they say this is for August. It's applied the way the statute says, which is first to any interest, then to late fees, then to any costs incurred, which includes attorney's fees, then to the delinquent assessment. So you kind of work backwards there. But that's how people then will have delinquent assessments that are going and going and going. Notice of late assessment. We call this the NOLA. You may hear that term of art all the time from your management teams or from your attorneys. If you want to start the collection procedure and you want to send your delinquent owners over to the attorney for collections, before you can do that, or before you should do that, I should say, you first have to send them this official sort of formal notice. Now, I assume you would have already sent them a late notice anyway. Your procedure probably is to send them some sort of reminder when they miss a payment, whatever. Now the statute outlines that you have to send this particular form, and it's a notice of late assessment or a NOLA. You can't collect attorney's fees in it for this purpose. So this is why we'll tell you, you should send this or have your management team send this before you send a file over for collections to us, because we don't want to do this letter for you and then you can't collect back the cost of us preparing this letter. This is something that should come from your management team, most likely, so that you don't have to, the association doesn't have to pay the attorney's fees. For every other collections notice, we put the attorney's fees on the ledger. You are entitled to collect it. This is the one exception. And again, the understanding is there was somebody in Tallahassee that didn't get his late notice or missed a payment or, missed whatever it was, and didn't realize his account started to accrue late fees and interest and attorney's fees and all these other fees. And when you miss a payment, it does start to snowball. And he basically freaked out and said, that's not fair. And we should make sure that everybody is sending this one last ditch notice before a file goes to collections. Okay, so here we are. It is a statutory form. It indicates basically what assessments are owed. And again, it can't include attorney's fees. That's the big catch. And it gives the owner 30 days to pay. Here's your balance, 30 days, or we're sending you to the attorney, essentially. And it has to go to their mailing address and the lot address if those are different. That's the other catch. And there has to be an affidavit of mailing that accompanies this notice. Typically, the assessment procedure, once you send it over to our office, there are 2 statutory notices that then the association's attorney needs to send. Those can build in the attorney's fees that were incurred to prepare the notice. So at that point now, we're sort of off and running. There are 2 notices, 45 days each. The first one says, here's everything you owe. We're going to record a claim of lien against the property if you don't pay it. If they don't, okay, now we've recorded the claim of lien. You have another 45 days, another notice that goes out. If you don't record, or if you don't pay this, now we've recorded the claim of lien. We will go ahead and foreclose that claim of lien, and we will file a lawsuit against you to do it. You have 45 days to pay. So you have 2 statutory notices of 45 days that tell the owner, we're recording the claim of lien, we're going to foreclose the claim of lien. If they don't pay, we're moving on, we're going to foreclosure. When you foreclose, by the way, and this is sometimes news to people, you can actually still take someone's property away. You will hear every now and again, someone will say, well, it's homesteaded, they can't touch it, or I have a mortgage, so they're not going to touch my property. Those things may be true, but it still means the association can foreclose. It doesn't matter. The association still has the ability to foreclose. In the case of a first mortgage, it would be subject to that first mortgage, but they could still do it. Homestead, doesn't matter. We can still foreclose. So be aware, make sure you're paying your assessments, make sure your owners are paying their assessments. If there is a mortgage, if there's a first lender that is also foreclosing or ends up foreclosing and maybe the association is actually getting paid, that's a whole analysis as well. Just what does the association get paid if the lender forecloses? What if the lender takes title? What if an investor takes title at the lender's sale? What does the association get? And there's a whole question about that too. Do we get safe harbor? That's the lesser of 12 months of assessments or 1% of that original mortgage debt. That may be what you're stuck with. That's as good as it's going to get if it's the lender that takes title at the lender's sale. Now, that doesn't necessarily mean that an investor gets that same benefit. If an investor takes title, they may owe you everything. The association, they may owe the association everything. But now you also want to look at your documents, because if the association has bad language, you may actually get nothing if the lender takes title. You may only get, okay, title forward, depending on the language in your governing documents. So this is a big analysis too. If you're thinking about doing amendments, that's another one to look at, because that's an easy amendment. And you want to make sure you're maximizing what you recover when a lender forecloses. Third-party bidder liability, like I said, it's not automatic. It's going to depend on what language is in your governing documents. If an investor purchases at that lender's foreclosure sale, what are you going to get? It depends. Financial reporting, we won't get into this in too much detail. Basically, you have to do financial reports. There's a whole analysis here of the level of financial reporting. It's all depending on what your total annual revenue is, what level of financial reporting you need to do. If you want to raise your reporting level and, do more than what your annual revenue would have required, that's fine. You can do that. If you want to lower it, you need a membership vote. That's if you're required to do an audit, you have to do an audit. Even if that's more expensive, you want to talk to your attorney, see if that's something maybe you should amend if your documents say something about an audit. But ultimately, again, you may need a membership vote to change your reporting level. There are certain disclosures that have to be in your financial reports. We'll include those there for you. Contracts and bids. Let's move into that topic. We talked about some of this a little bit when we talked about conflicts of interest, but contracts in general, and listen, I'm an attorney. I'm going to tell you the most basic thing I can tell you as an attorney. Get it in writing. Now, the statute says contracts have to be in writing if they can't be fully performed within 1 year, or if it's a service type contract. That's all well and good, but I'm still going to tell you, get it in writing. And really have your attorneys look at it. You have no idea how many clients we have that sign a pretty big contract for $300,000 to do, concrete restoration or to fix the clubhouse roof that I keep talking about. And then they come back to us and they go, this vendor stinks and we're not happy with the work they're doing. And there are all these delays. And can you get us out of this contract? Well, you didn't have us look at it to begin with. So now it has some bad language and stuff that we would have taken out and things we would have changed if you had just let us look at it before. You are running a business. It's important to remember you guys are running a business. So yes, even though you want to save the association some money, and I appreciate that, you also need to, again, fiduciary duty, you need to do your due diligence. You should have your contracts reviewed by counsel. Save a little, put some money aside. And ultimately, in our opinion, it's going to save you in the end. If there is an issue with a vendor, maybe hopefully we can avoid that altogether if your attorney reviews your contract in advance. Now, any of your contracts should also spell out, obviously, the obligations of the party, the costs, the frequency, if we're talking about services. Those are things that should be in there. Now, in general, when we talk about bidding, we always get a question, do we need multiple bids for this? Well, if the cost of the contract is more than 10% of the total annual budget, including reserves, then you do need to get competitive bids. Now, we say bids, but the statute doesn't say that necessarily means 3. We're still going to recommend 3, but bids is just plural. So plural means 2. But we're still going to recommend. That doesn't mean only 2. You can do 3. You could do 4. Up to you. The association's not required to accept the lowest bid. That's another important piece of information you should be aware of. Just because you got 4 bids and one guy came in much, much lower, that doesn't mean you have to pick that vendor. Maybe you, for whatever reason, just got a bad feeling. Maybe the board didn't like their interaction with him. He took too long to email them back, or, whatever it was. Or this other bid that's in the middle is actually the same guy who did the work in our neighboring community, and they raved about him, and their board said he did a great job, and we think they look great. So we want to use that guy. That's fine. Again, you don't have to take the lowest bid. You just reasonable business judgment. You need to be reasonable in your decision making. And something like that would be a perfectly logical explanation, perfectly fine. If there's an emergency, you don't need to get competitive bids. If there is the only person in the county that has that item, you don't need competitive bids. I've only seen that once. That's about it. Let's see. There are certain requirements or certain contracts that are exempt from the bidding requirement. I kind of call it your professional contracts. Your attorney, your accountant, your architect, your CAM, those are all exempt from bids. I mean, you may want to get multiple, proposals, but you don't need to do the bidding procedure for those items. Estoppel certificates, and we include this in here because you might want an outline of what really your estoppel is supposed to include. I'm not going to go through every slide. We have a lot of slides on this. But ultimately, what you need to know is if you get an estoppel request, you need to respond within 10 business days. Either your management team is handling it, or if you're self-managed, this is something you need to handle as well. You can charge for it, but basically it's a payoff. It's probably because someone is trying to do a closing. They need to know what's owed. The bank wants it. The title company wants it, whoever it is. It has to comply. It has to have this information in it. We won't go through again too much of it. The important thing to know is you are putting an amount that is owed to the association on this estoppel, and you are indicating what violations are outstanding. So if that is wrong, if you give them the wrong information, if you tell them that, only $5,000 is owed as of, December 1st, and you forgot that there was a special adopted last month that you didn't include, and they pay the $5,000 because you put $5,000 on the estoppel, then guess what? Now you have to eat that special because you are stopped from collecting it because you didn't put it on the estoppel. Same thing with a violation. If you put a violation, or if you put that there's no open violations, and someone buys the property and they move in, and you immediately, as the association, send them a notice, oh, by the way, the house was painted and you never got approval for the house color. Well, but this is the same paint. I just moved in. I didn't paint it. You told me there were no open violations. What do you mean I have to get approval and I have to repaint the house? All things to be aware of. If you're filling out an estoppel, make sure the information is correct, because you will run into problems if it's not, and you try and enforce later on. There are fees for estoppels to prepare them. That's all well and good. Covenant enforcement. This is really the big item. This we could spend, 3 hours just talking about covenant enforcement. What you need to know, and we've touched on a lot of these topics already, is the association is responsible to uniformly and timely enforce its governing documents. Now, as a board member, you probably don't love being the bad guy, but this is part of the deal, okay? That's part of the job. Sorry. You can't just say we're not going to enforce anything because we like our owners and we don't want to cause trouble. No, it's part of the job. You have covenants and restrictions for a reason. You have to enforce them. So architectural standards, pet restrictions, parking restrictions, leasing restrictions, you guys have to enforce all of those things. You have to send notices when there are violations. You need to pursue them when we're past the notice point, and actually, proceed with any other means to compel compliance from your owners. First thing is always going to be send them a notice, give them a chance to fix it. Hey, not sure if you knew that you can't park on the street overnight, or whatever your violation is. Article 10 says no trucks. Please make sure your truck is, in the garage overnight. And we won't get into the whole truck discussion again. Let's just go with that. All right. Give them a chance to fix it. See if they comply. If they don't comply, you do have other tools in your tool belt, because I'll hear people say we send notices and then that's it and we don't do anything else. Well, that's a problem, because you're not going to be able to enforce your governing documents if you just don't try. You can fine owners, you can suspend their use rights, you can suspend their voting rights. You may have to actually end up in litigation. That's another option. I know it might not be your preferred option. You might not want to end up filing a lawsuit against your neighbor, but that might be what the association has to do to get the owners to comply. First thing is, fines and use right suspension. Essentially, the association has the authority to fine and suspend use rights. Now, the board has to levy a fine at a properly noticed meeting. Then you have to send a notice to the person. You have to give them a 14-day opportunity to have their hearing, 14-day notice to come before the hearing and proceed. Now, hearing has to be held within 90 days after issuance of that hearing notice. The board essentially decides, okay, we're going to fine someone for this violation, and then we're going to send it to our fining committee or our grievance committee or our covenant enforcement committee or whatever you're calling it, but fining committee essentially. Fining committee just votes yay or nay, just says, we looked at the pictures from the board or from the management team. We do see there's a violation. We see they haven't fixed it. We see the letters they sent out. So yes, we're agreeing with the board's fine of $1,000, $10 or 10 days for $100 each for a continuing violation. Now, the problem is then you have to send a notice. You have to send another notice to the owner, letting them know that how that violation can be cured and what's owed and what the fine is and when it can be paid. The problem is now they've changed the statute to say if the violation has been cured before the hearing, the fine cannot be imposed. This is the part we don't love, because this confuses things even more. Because if the violation was, you were supposed to park in your garage and you're leaving the vehicle in the driveway and the vehicle's been there for 10 days and it's $100 a day, so we're up to $1,000 fine. But if the violation has been cured before the hearing, you can't fine anymore. So let's say, does that mean If the person moves the car, moves the truck, now the truck's in the garage, they moved it 5 minutes before the hearing, or they drove to the hearing in the truck, so it's not in the driveway anymore. They fixed it. Did they cure it? Not so easy to figure out. Very fact specific, talk to your attorneys. What does that mean? Does the fine go out the window, or do we still have a fine because they couldn't cure it because they didn't take it out of the driveway in those 10 days? Very confusing. The way they tried to change the statute made it a little messy, to be honest. So talk to your attorneys, see how to proceed with fining now. The other part of this is attorney's fees can't be awarded against a parcel owner based on actions taken by the board before the date set for the fine to be paid. So any attorney's fees that are incurred in sort of this this earlier portion of the violation, you're not going to get those back as the association. It's just going to be a cost of doing business now. A fine, like I said, can't exceed more than $100 per violation unless it's on a continuing basis, and then you're up to $1,000 in the aggregate. $1,000 really is the max under the statute, unless there's language in your governing documents that lets you go higher. So again, if you're thinking about amending your documents, that might be something else you want to look into. Give yourselves the authority to go higher than the $1,000. If it's a fine of $1,000 or more, it can become a lien against the property, and you can actually proceed like you would be collecting a special assessment. You can lien, you can do a foreclosure process to pursue that fine. If you don't have that authority in your governing documents, then you can't do it that way, and you're ultimately kind of stuck like it's small claims court, like it's just a debt that you're going to put on the ledger, and if they don't pay it, then what? Use right suspensions, that's another one you can do if somebody is in violation of the governing documents. You can't suspend them from accessing the community. You can turn off their clicker, you can turn off their sticker, their transponder, their car key, their key card, whatever it is, but they have to be able to get in. So if you can make it so that they can't go through the resident gate, but they have to stop at the visitor gate, and they have to, stop and talk to the security guard every single time, that tends to drive people crazy, and they hate having to do that. But they have access still. They have to have access to the community. So you can kind of, put a speed bump up in the way, but they still need to have access. You can't keep them from parking. You can't keep them from, accessing the community or their lot, but you can make it more difficult and make it inconvenient. This was another change to the statute last year that is very bizarre. Again, I'm not sure what politician came up with this, but ultimately the association, now there's language in the statute that says you can't levy a fine for any of the following: leaving garbage receptacles on the curb or the end of the driveway within 24 hours before or after the designated garbage collection day. And I will tell you, we have communities that are townhome communities where the garbage collection is twice a week, which is all well and good. But if we're talking garbage cans are allowed to be out the day before and the day after on either side of garbage collection day, and the garbage collection day is twice a week, that means 6 days a week, they can just have garbage cans throughout the community and they can't fine for them. And they don't love that because, again, it's a townhome community. The properties are very close to each other. Driveways are very close to each other. And now you just have garbage cans, as far as the eye can see. But again, you could have a Kaufman discussion about this. Is that something you can enforce in your governing documents anyway? Can you enforce it but just not levy a fine for it? All considerations, talk to your attorneys. The other one you can't fine for now is leaving holiday decorations or lights up longer than the period in your governing documents, unless they're left up longer than 1 week after the association provides a written notice of the violation to the parcel owner. Use right suspension. So like I said, if somebody is delinquent, this is another tool in your arsenal here. If they haven't paid a monetary obligation in more than 90 days, you can suspend their use rights. So this is something that doesn't require a committee hearing, doesn't require, any of that. It's just a board decision. The board may want to do this regularly at their board meetings. Look and see, you might want to make a motion to suspend the use rights of everyone who's over 90 days delinquent. And then you send them a notice that we decided to suspend use rights for everyone who was over 90 days delinquent, and that included you. So we're turning your transponder off, on this day. You can do that, talk to your counsel, maybe make that a common, frequent thing if you have a delinquency problem, and turn off transponders And I'm telling you, that gets people's attention. It drives them bananas when they have to come through the security gate and stop and talk to the security guard, and they can't just fly through the resident gate. Drives them nuts. Back in the day when I did collections work, we had a guy who called and he said, my wife and teenage daughter are ready to kill me. My wife might divorce me if I do not figure out a payment plan. What do I need to do to get my transponder turned back on? If they have to stop and talk to the security guard one more time, I might end up in a divorce. Please tell me what I need to do to pay the association. Because again, this is if you're delinquent in greater than 90 days. Like I said, it gets people's attention. They don't like having to do it. Now, same thing we talked about. You can't keep them from coming into the community. You can't keep them from parking, but you can turn the clicker off and make it more difficult. All right, voting suspension. This is something where you want to talk to your attorneys before you consider suspending voting rights. There is an argument here about whether or not you can suspend voting rights pursuant to the statute, or if there's language that needs to be in your governing documents. There was a case recently that said basically that, again, depending on the year of your governing documents being recorded and when the statute changed, there was an issue there where the board improperly suspended voting rights. So talk to your attorneys before you think about it. But that's something else. Typically, we find if someone's not paying, the odds are they're probably not voting anyway, and suspending their voting rights is probably not worth it, but talk to your attorneys. Last possible, your Hail Mary to get them to do what they need to do. You might need to file a lawsuit. You might need to go to mediation first. You send them a pre-suit mediation demand. Or if there are certain exceptions where you don't go to pre-suit mediation. If we're talking about collecting assessments, something like that, that doesn't go through pre-suit mediation. But ultimately, your first step before you file the lawsuit is probably sending them a pre-suit mediation demand. Hey, owner, you're not supposed to have a truck in our community. We've told you this 1,000 times. Truck has to be either in the garage or can't be parked on the street. We're sending a pre-suit mediation demand to try to get this resolved. Let's go to mediation. Let's see what we can figure out. The association might be on the receiving end of a pre-suit mediation demand as well, because it covers a whole bunch of different disputes. Owners might send you a pre-suit mediation demand. If you get anything that at all resembles a pre-suit mediation demand, talk to your counsel, get it to your insurance defense if you're a board member right away, because there are time frames. You have to respond. You have to actually go to mediation. There are penalties if you don't show up for mediation. But let's assume it's a covenant violation issue. We have an owner who's doing what they're not supposed to do, and the association sends them the pre-suit mediation demand, and we're trying to get things worked out. Let's assume that's our scenario. So you would send them the pre-suit mediation demand. Again, there's time frames and how we send this and how much time they have to respond. You have to include a list of mediators. You pick 5 mediators. They then decide if they like one of them, and they'll agree to one of them. They have to select one. They have to respond within 20 days. You have to schedule the mediation within 90 days. The parties share the cost. There is a cost to mediate. The mediators are usually retired judges or their attorneys, and they may tell you it's $500 an hour and minimum 2 hours to try and get this worked out. The way they did this with the statute, they were trying to, make things easier and get owners and associations to resolve things without having to file a lawsuit. But still, mediation could still be, an expense. Still meant to be cheaper than filing a lawsuit, but not always. If you don't show up, if you don't pay, if you don't cooperate, if you don't do the things you're supposed to do, then there are penalties. If you go to pre-suit mediation and there's an impasse, also, again, the next step is you would be filing a lawsuit to proceed. An impasse is essentially if someone doesn't respond, if they fail to agree, if they fail to make the payment, if they don't show up for the mediation, all of those good things. And again, there is a penalty. If you don't comply, you ultimately win in the lawsuit, you might be penalized and you can't get your attorney's fees back. Your attorney's fees are awarded only if authorized by contract or statute. Typically, the statute and your declaration are going to allow for attorney's fees to be recovered if you're enforcing the provision in your governing documents. So if the association is bringing an action to enforce the violation, to get your owners to comply with your declaration, there's a basis for the association to be awarded attorney's fees. If the matter is resolved at mediation, great, then maybe it's over, we're done. But like I said, if the person fails or doesn't participate in the mediation down the road and They prevail. The penalty is they don't get their attorney's fees back. That's your penalty. That's your punishment. Self-help versus injunctive relief. This is an important topic, and this is quite confusing. And I would tell you, go to our website, because we actually have a Rembom's Roundup article from December 1st on this, because there's sort of a new case that has changed things. Self-help, your declaration may or may not have language about self-help. In the world of, maybe a maintenance violation, hey, we need this owner to weed his driveway because the driveway has a bunch of weeds and the owner's not doing it. What do? We've sent them letters. We've fined them. We've told them we're going to sue him. We're doing all these things and he just ignores us. What do we do? Well, before you file a lawsuit, you may say, well, our governing documents actually say we could do the weeding of the driveway. We, the association, we could have our landscaper maybe go do it. And then we can either there's language that says, and we'll charge it back for him, or we'll charge it as an assessment, or we can just attempt to get reimbursed. Hey, the landscaper, charged us $200 to come do it. We'll pursue the $200. There is always a question of, can we do that? Do you have the authority to do that? Can we do self-help is what we call it, or do we not have that option? First, that's going to depend on what's in your governing documents. And you want to make sure you consider whether you want to do that or whether you just want to file the lawsuit and you want to get injunctive relief and ask a court to tell this owner you need to go ahead and weed your driveway because you're in violation of the governing documents. There's a whole analysis involving whether or not you have to do self-help before you can file injunctive relief. There were cases about it. Some of the cases, I think it's the first and sixth district, were telling owners that, or telling the associations, you have to try self-help first. But then someone in the fourth DCA, thank goodness, realized maybe you shouldn't tell associations to just walk onto people's lots and do things, because people don't respond well to that, and that might not go over well. So you should file a lawsuit instead and let a judge decide. So there's conflicting case law on this, depending on where you are and which district, and we don't know exactly which way that's all going to pan out. So that's something to discuss with your attorneys as well. Okay, I did it under the 3 hours.
You made it. Great job. Folks,
give everybody the info and I'll look and see what they.
Yeah. Emily, just for your reference, the last question, I know you're not going to get to all of them, but the last one that we're going to consider, it should be timestamped by Rendon at 2:36 p.m. So at that point, don't go beyond that.
Okay.
Otherwise, we'll be here forever. And folks, if you didn't already press the chat button so it appears, that means you have not seen the link for the evaluation. So please press the chat button so it appears. And in about 30 seconds, I'll place the link in there one more time. After you fill out the evaluation, the required part is over. The Q&A portion is bonus, extra. You do not have to remain on for that. And so again, after the evaluation, you can go. I'm going to place the link in there again. Let's see. Evaluation. And then when you click on that, a tab in your browser should open up. And this is what it looks like. Okay, anywhere you see an asterisk, it's a required field. We changed it and made it a little simpler. You don't have to put your whole address in there, just your city, county, and zip code. And make sure your email addresses match here. And after you submit it, this is some of the information that you'll see, including Emily's contact information. And here's the one that many of you asked about, the third bullet point. To save today's slides is the third bullet point. Just click on that. Another tab opens up and you can then save them or print them. And then, hey, we've because of you all, we've won the Reader's Choice Award 11 years in a row. We're looking for number 12. So if you have an extra 30 seconds or so, it doesn't take long at all. Just click on that sucker. And there's just 4 easy fields to fill out. That would be much appreciated. So Emily, back to you for some Q&A, and then I'll come back and go over the evaluation process a little more slowly for everybody.
Okay. I saw some that were quick answers here. Someone said if we got multiple requests for bids sent out, but only 1 or 2 vendors respond, what do we do? Now, again, it does say you're supposed to get bids plural. So if at least you get 2, you should be okay.
Yep.
I didn't see fines on the application of late assessment fees. Right. So now, again, on that, if we're talking about your NOLA, you could have a separate category for fines when you're listing what's owed. But when we're talking about the application of payments, that's a little different because your fines really are not, unless you adopt them as a special assessment and you're going to lien for them, then they're sort of in their own category. So it gets a little confusing, but it's going to depend on the authority in your governing documents. Talk to your counsel, see if that's something either you kind of have to handle separately, or if that can be essentially treated as an assessment if you do it that way. Let's see. Can the association prohibit work on a holiday? Probably. Whether you can do it by rule or in your declaration, probably going to be fine, but you'd have to see how you need to do it and what the authority is for rules and that kind of thing in your governing documents. Someone said if the association's using cameras, can the video be used to show the issues, or is the video only open for viewing by the board? So this is a question too, of if recordings are part of your official records, and do you have to then share them? Now, there is a question about that because the statute only says written records, doesn't really say anything about recorded records. And then also, does your security system actually record and keep all those videos, or is it one of those where it just records over the same tape for after 24 hours? You may not actually have a record of, that fender bender that took place 6 months ago. But ultimately, talk to your counsel, but generally it may not be part of the official records. It may be something that you would provide if law enforcement asked for you for a subpoena and gave you something for something like that. But if an owner's just saying, hey, I want to see the video because a black car came racing in and I want to see who it was, that's probably not something you need to address. But talk to your counsel. Depends on what the request is, who it's from, all that good stuff.
And James, who posed that question, I'm putting a link for a class that Alan taught late in October. It's called Cameras and Community Association. Somebody's watching me. That'd be some great reference for you and everybody else on the call here.
I know there's a long question here, but the bottom line was, he said, can you advise on the feasibility requirements and procedure for expanding the board? And that's a good question because usually, and honestly, we usually hear the opposite, that people can't get owners involved and there is not enough interest to fill the board. But if you actually have people that will want to serve and you can increase the size of your board, great, more power to you. You have to look at your articles and your bylaws, because your articles and your bylaws probably say something like, the board must be between 3 and 7, or may say a board of 5, but it's really going to depend on the language in the articles and bylaws, whether or not you can do it and whether or not it requires a board vote or a membership vote. Maybe it says 3 to 7 as decided by the board, or 3 to 7 as decided by the membership, which would mean now your members need to vote to change that number, which might be hard to do. Or maybe it says 5 and then you would need to do an amendment to change that. So lots of different variables that could be at play there. It depends on what's in your governing documents is the general answer there.
Hey, Emily, at the risk of putting you on the spot, Lou put a question in the chat by accident. So folks, put the questions in the Q&A, not the chat. Pretty general question. Best practices for collecting past due assessments. Do you have 1 or 2 tips you could mention?
Well, so again, now I don't know if you have a management company, but if not, talk to I guess whoever's doing your bookkeeping at least. But first thing, you want to send that you either a late reminder, whatever it is, but you can send that notice of late assessment right off the bat. You don't have to send multiple late notices and then the notice of late assessment and then send it to your counsel, because realistically, your notice of late assessment gives them 30 days to pay. That's going to give them an update of everything that's owed. They have 30 days. Now, when you send it to counsel, obviously some time has probably passed. Counsel has to send 2 statutory notices that are 45 days each before we can go to foreclosure. So if you've waited months and then you send that notice of late assessment, and then the attorney sends the first notice, and then the attorney sends the second notice, you might be like 9 months into the year where this person is not paying before we can get to foreclosure. So the first thing we're going to tell you is be aggressive with your collections procedure. And I don't mean it in a heartless way. If your owners have an issue and they come to you and they want a payment plan and they tell you, can we work something out? It's a hard time for me. You guys as a board have the ability to agree to payment plans. You can do that. You can exercise your discretion, but be aggressive with your collection procedures. Get your collections turned over and moving along, because again, you guys need money to operate. You need to be able to function. So you
Right.
got to get your owners paying. So that's my longer than 2 seconds, but Cliff Notes answer for you.
All right. Let's wait, what is it? 3 minutes to go. Let's do one. Is there one more that's not a novel?
Well, someone said a quorum of the board, can they discuss business by email or email group? Okay, so this is, and I should have clarified essentially what a board meeting is. There is a whole dispute about what even is a board meeting. What does that actually mean? The definition that we use, because this is what's thrown around, is when a quorum of the board is gathered to conduct association business. So now again, not the best definition. What does it mean to conduct association business? Does it mean you're just chatting about association stuff? If 3 out of the 5 of your board members just run into each other by the pool and you're all chatting and saying, oh, I like the paint color, the clubhouse looks
My
great,
God.
the pool looks nice, our pool guy's doing a good job, guys, what do you think? Yeah, the flowers are looking good. I don't think you're conducting association business. If you're,
Well,
making small talk, you are talking about association stuff. I understand.
how the heck are you supposed to garner research to
Right,
bring back to,
right.
that you and we
If you're
debate
actually
about this all the
voting,
time.
right. If you're saying, hey, while we're here, I think we should hire that new landscape company. What do you guys think? Yep, let's do it. Let's sign the contract tomorrow. That's different.
That's
Now you're
different.
conducting association business. Don't be doing that at, where it's not a properly noticed meeting.
Maybe a term is like making decisions versus
Yes.
discussing.
That's what we say. If you're taking action, it should mean you're voting, you're actually taking action. You're making decisions, you're voting, you're moving forward. If you're just sort of chit-chatting, I don't think that's an that's not a board meeting that needs to be noticed and open to owners. But again, there are some attorneys that will be very conservative with that and will basically tell you quorum of the board should never be together, essentially.
It's like when you have a town hall meeting, for example,
Right.
and you're discussing stuff without you're just like throwing options out there, but the entire board is at the town hall. Does the town hall have to be noticed? Does it have to be recorded? I mean,
Right.
yeah, it's a whole, yeah. Sorry,
Love
sorry to
it.
interrupt. That's
No,
when I
it's
was
fine.
on the field, that was a major issue all
It
the
is.
time.
It is. It's a question we get all the time. And boards will say we don't want our owners to think that we're not, being transparent or that we're trying to hide anything. But at the same time, how are we supposed to get things done if we can't have, if we can't talk to each other ever?
Right. Right. I know you have to run. It's the top of the hour. I'm going to turn off the Q&A. Emily, thanks so much for everything, as
Thank you
always.
guys. Thanks so much. 3 hours. It's long, I know.
It's
But
like, yeah, you should all be consider yourself lucky you're not in a condominium. That's 4 hours and change. So
yeah,
it's
yeah.
could take even longer. So before you go, the best way for folks to reach you, and when Emily leaves, folks, I will remain on for a few minutes. I'll go over the evaluation much more slowly. Also, how to download the slides if you haven't figured it out. But before I do that, Emily, best way for folks to reach you.
Yeah, you can send us an email. Obviously, we have our website, kbrlegal.com, but just you can send me an email, egannon@kbrlegal.com. And then I'll tell my mom that you guys all said I did a great job. Just kidding. Thank you. Thank you so much, though.
She's still here. I think she just heard you say that. So
Okay, good.
have a wonderful day. It was
All
good
right.
seeing you last week. And